Well, our item number 26. Here I am appearing for the for the first time for respond number 4. I pray for some time to file our affidavit, at least 3 weeks time. He is for the petitioner.
Some time or some days?
Some days.
When? Just tell us a date.
After 3 weeks, my lord, in the second week of May, my lord, 10th
10th
of May, my lord.
No, which item? 26.
26, my lord. I've got the authority to appear for respond number 4.
Okay.
The
You're taking consent?
Lordship, there is an interim lordship.
Okay, both sides are represented. On the prayer made by standing counsel for the health department, matter since adjourned to another room to file affidavit in opposition in the matter. Next, list on when?
On 10th of May,
10th.
or any day convenient to this honorable court.
We'll make it 8th.
Month.
8th of May, 2024.
Lordship, I recorded I am appearing for respond number 4 also, because there was an order for dusty service. They have taken my presence may be recorded for respondent number 4.
As well as respond number 4.
And on this.
But interim order stands extended.
Maybe yes. My lord, I beg to mention in respect of item 33, my lord, I am for the petitioner. In fact, my lord, this case is wrongly listed for orders. My lord, in fact, the notice has not been issued, my lord, in respect of all the respondents yet. So at best, my lord, it would have been listed for admission. Now, my lord, since I have some urgency in the matter, item 33 may not reach. So your lordship may take up as an admission item, my lord, at 2 p.m.
Okay,
Item
inform the
30.
other side.
I will, my lord, in fact, all the state response and the respondents are there. I'll inform, my lord. Obviously. 33, huh? Good order.
My lord, I beg to mention item number 13, my lord, part hard matter, my lord. Can you take up the matter at 2, my lord? Yes. 13, my lord, part hard.
Okay, inform the other side.
Yes, other side, my lord, I will inform you.
Okay.
May I please, your lordship, I beg to mention item number 25. Allow us 4 weeks time to file our affidavit.
Okay. You're taking consent?
25.
Okay,
Yes.
for the petition.
Both sides are represented. 3 weeks time.
4 weeks time.
4 weeks. On the prayer made by the Learned Counsel for the CGST. List after 4 weeks to enable him to file affidavit in opposition in the matter. There's any interim order operating?
Lordship, there's an interim.
Interim order stands extended. Next date of the state.
Please,
Deeply obliged.
victims on item number 11, my lord. Kindly adjourn for that day, madam. On behalf of Chief Sharma, madam.
Okay. You're taking consent of the bank?
Yes. Yes, sir. Please, Sharma, can I come to?
Okay. Both sides are represented on the prayer made by counsel for the petitioner. List after
Bihu, my lord. Bihu vacation.
ensuing due vacation.
May it please the lordship. Lordship, with the consent of the respondents, I would like to mention item number 32. With the consent of the respondents, my lord, I would like to mention item number 32, the daily list, my lord. The matter may be adjourned for today and be listed after maybe 4 weeks, my lord.
Both sides are represented on the prayer made by and counsel for respondent number.
My lord, I am for the petitioner.
Okay,
We have
the
the
petition of
consent
the
of
matter
the
stands adjourned today. List after.
8 weeks, my lord, there is no interim or
Okay. Give a date after the interim order stands.
no interim, my lord.
Yes.
Obliged, my lord.
Lordship, I beg to mention item number 5, your lordship. This is a motion stage, but this is the first time. The engaged counsel, Mr. Espiro, is out of station, lordship. May it be adjourned for day.
On the prayer made by counsel for the petitioner. Matter stands adjourned today. List after.
After 1 week, lordship, maybe 10th of April, it's possible.
10th is last day. We are not fixing on the 10th. Make it 9th. 9th.
Obliged, lordship. Highly obliged.
May I please your lordship, I beg to mention for listing lordship, matters some urgent, can be fixed for Monday.
What is the urgency?
Land allotment matter relating to. Urgency, lordship, matter relating to land allotment.
Land allotment is not urgent. After we give to him.
May please your lordship. Lordship, I beg to mention for listing of a matter for Monday, lordship.
What is the urgency?
Lordship, urgency is that the matter last came up on 17/8/2000.
Not before viewing, after viewing. We had so much of time.
Lordship,
could have
matter
done it
last came
earlier.
up on in the year of 2021, lordship.
You could have done it earlier. Why just before view? You know the pressure which is created during this time.
Lordship,
After viewing.
there is some urgency, lordship.
I can't help it. I can't tax myself. Then
May I please your lordship. Lordship, with the consent of the other side, I would beg to decide number 35, my lord. My lord, in this matter, I pray for an adjournment for today, my lord.
35.
Yes, my lord.
You're for?
My lord, I am for the respondent in the IA, my lord. For Asgore Thakur, my lord.
What is this IA for?
My lord, this IA is submitted by the respondent, my lord, stating that, my lord, they are not a necessary party in the petition, my lord. So, my lord, we have an objection to that, my lord. We'll file our objection, my lord.
Okay. You've taken consent?
Yes, ma'am.
Okay. What says the representative?
Okay.
On the prayer made by the counsel for the opposite party in the interrogatory application, the matter stands adjourned to enable him to file affidavit in opposition in the matter. Matter stands adjourned today. List after entering the occasion.
Obliged, ma'am.
Daily list item 1 for withdrawal.
Yeah, please.
Upon instructions, Mr.
Yeah, ma'am.
A. Ahmed, counsel for the petitioner, is to withdraw this this bail application. Prayer is allowed. Mr. K. Das, Lamine, APP is present. Matter since dismissed from withdrawal.
Item 2.
May I please, your lordship? Lordship, this is an contempt petition, your lordship. Your lordship, willful and deliberate violation of order dated 13/10/2023, your lordship. Passed in WPC number 5360 of
Where is the
2020.
order?
Order operative part as page 10, your lordship.
Alleging Mr. S.I. counsel for the petitioner, alleging willful disobedience of order dated 13/10/2023, passed in WBC 5360 of 2023. This contempt petition has been filed. Issue notice returnable on so and so. Petition shall take steps within 2 days for service of notice on the respondents by registered post with AD. Next, the tendency of the petition shall not be barred for the respondents to comply with the order of the court. This after 4 weeks.
I'm deeply obliged.
Item 3.
The last occasion I was directed to obtain instructions, but I've written to them, they've not responded. The officer in charge, Modification. Why his FIR dated 6/1/24 was not registered.
Mr. BPC not counsel for the Mr. BC not counsel for the petitioner. It is alleged in this writ petition that the officer in charge of Jalubari police station, Jalubari outpost, called the petitioner number 1 to the police station, to the police outpost on 19/3/2024, and he was detained illegally from 10 a.m. to 7 p.m. and was released only after procuring 3 checks bearing number 0000 site 0 dated 10/4/2024 for rupees 1 lakh 00065 dated 21/3/2024 for rupees 1 lakh, and check number 000066 dated 25/4/2024 for rupees 1 lakh. Out of the said checks, the respondent number 7 has withdrawn check, has a cash check number 000065 dated 21/3/2024. Accordingly, the petitioner number 1 had lodged an FIR before the Nulmati police station, which was not registered. Hence this writ petition. Next, the session on it, government advocate agreeing for the respondents. Respondent numbers 1 to 6. Next, in matters like this, the law is well settled that in the event the police does not accept the FIR, it could be open to the informant to either approach the Commissioner of Police of Kamrup Metro District, lodges complaint, or to move the jurisdictional magistrate for registration of a complaint on refusal of the police to register an FIR. Therefore, this is not found to be an appropriate case for issuance of writ. To direct the police to register an FIR, as the petitioner has an alternative remedy. Stop. Yes, thereby by granting liberty to the petitioner to avail any alternate remedy which they may avail. Petitioners, yes, there is a comma. This petition stands closed. You're giving you liberty.
Yes.
The petitioner is also at liberty to produce a certified copy of this order along with his,
I love it.
along with steps taken.
I like.
Also, just a moment, just a moment. Here, just record that the OC did not accept your call.
The OC Nunmati, yes.
Just before the Learned Government Advocate has submitted that person to order of this court dated 1/4/2024. She had made an attempt to contact the officer in charge of Nunmati police station. But her calls were not received by the officer in charge of Nunmati police station. Said statement of the Learned Government Advocate is taken note of.
I had written to him, my lord. not-
Written?
Yes.
Yes, sir. She has written to the officer in charge, but she did not respond. This time, the said statement is noted.
Item 4.
Yes.
Lordship, I'm challenging an order passed by the CGST authorities.
This seems Cal.
I do not feel him in the court, Lordship.
Just wait for some time. Let him do it.
Item 6.
May I please, Your Lordship? This application is preferred for non-disposal of my application made under victim compensation scheme for granting compensation before the District Legal Service Authority, Kamrup Metro Guwahati. My application is page number 29.
Relation notes here.
Lordships, in verbal instructions, your lordships, his application has been disposed of. In fact, the next page, if your lordships will peruse, your lordships will find that a victim compensation case was also registered. And they were called for submission of documents, which I am told verbally that it has already been disposed of. But because of paucity of funds, your lordships are aware that we had a lot of backlog of cases. In fact, there's a PIL which is listed before the Honorable Chief Justice today as item number 24, which is taking note of this paucity of funds with a salsa. And lordships, and the government advocates have been made to get instructions by today as to why funds are not being released to
Such as
the
if you have noticed,
lordships.
and then we'll take it up after 2
As
weeks.
soon as the funds are, and in fact, my verbal instructions are that the case has already been disposed of and this thing has also been granted. But unfortunately, because of paucity of funds,
Okay. Mr.
Adhaar.
Adhaar counsel for the petitioner, as well as Mrs. R.S. Chaudhary Lamek,
lordships,
counsel for the
respondent number 2.
respondent number 2,
Lordships.
and Mr. Yash Sharma, on the committee advocate appearing for respondent number 1, 3, and 4. anything non-disbursement of compensation to the petitioner under the victim compensation scheme. The present petition has been filed under Article 226 of the Constitution of India, wherein it is projected that the husband of the petitioner had died in a road traffic accident caused by a unknown offending vehicle who had hit and run the motorcycle of the petitioner, resulting in death of her husband. Next paragraph. The learned standing counsel for respondent number 2, upon verbal instructions, has submitted that the respondent number 3 has in the meanwhile disposed of the claim petition of the petitioner, and as per her further instructions, due to paucity of fund, the compensation could not be released. Possibly funds as adequate funds are not placed before the respondent number 2 and 3, the compensation amount could not be released. If you notice, returnable in 4 weeks, requisite extra copies of the petition be served on the learned state and the learned standing counsel for respondent number 2 in course of the day. Next, the pendency of the petition shall not be a bar for the respondent number 3 to disburse compensation amount to the petitioner if so assessed, as and when funds are placed with the said authority. This after 4 weeks.
Obliged.
7.
Yes, please, well. My lord, the petitioners and other their associates are the Hajj pilgrims of 2023. They are entitled to get refund of their excess airfare. And they submitted representation as page 43, my lord, to the Central House Committee. But in respect of the Hajj pilgrims of Kachar district, my lord, there is already an order at page 65, my lord. I pray for disposal of the representation only.
You have to satisfy us. You see, come to section 27 of the Hajj Committee Act.
Yes.
You have to see that unless you see that you can't respond. You have a copy of the act.
No,
You see, the duties of the committee is to implement the policy and directions of the committee in the interest of Hajj pilgrims.
Yes.
Number two, the state committee shall provide assistance to the Hajj pilgrims,
Yes.
including in the matter of their transport between their home states and the point of exit from India and their transit accommodation at points of exit.
Yes.
The state committee shall discharge such other duties in connection with Hajj as may be prescribed by the state government concerned in consultation with the central committee. Now, the refund of
refund has to be by the central committee.
no, I understand. But section 42 says that if they will do their duty as prescribed under, they will perform their duty.
Yes.
They have to show us that refund of international flight is a part of their duty.
Duty of the central Hajj committee. We submitted
No, whatever it is.
representation.
Please show us that this is a prescribed duty.
Yes.
Because
Under
you
section
see-
42, it is mandatory that they have to dispose of our representation.
No. In respect of their duties under, that's why I'm reading this section 27.
Yes,
Their duties up to exit point.
yes.
Refund of flight till Makkah would be beyond the power of the duty of the Hajj committee.
They collected the money from us
That we don't
for
know.
chartered flight.
You see,
They sent us by ordinary flight.
show us from within the act.
Yes,
Because unless the court is satisfied,
Yes.
it's not a question of representation.
yes.
Correct.
Yes.
There are some representation which we may not direct the government to act.
Yes. Only direction I'm
No.
saying for is
Let
only.
us say one gentleman comes to the court and says that I want to file a representation to the government. Please make me chief minister.
No, madam. The rule must be seen, madam.
So please show us that rule. That's why we are showing you this 27.
Yes.
And we are asking you, what is their duty?
So at least notice may be issued
No.
so that
No.
they can.
No. Why you please explain it to us?
Yes.
Please explain to us that is a part of their duty.
Then some other day it may go.
But it goes after vacation then.
Yes.
District motion column after answering vacation, review vacation as paid for by the council vacation.
Item 8.
Please, Lord.
Yes.
In this case, my lord, the way back in 2017, the case was filed, my lord. Nothing has progressed as on today, man. So at this stage, the report may be called for, man.
But why we have a writ petition? Why not under 482?
But I understand. It is also maintainable. It is not,
It would not be maintainable.
because my rights under Article 21 has been violated for last.
No, you have a remedy under this under 482. Move the court. Number 2, you can file a complaint. It will not be a bar. Writ petitions normally, all these writ petitions which are on record, they come originate from Uttar Pradesh, where 482 was not available for many purposes, as well as 438.
Yeah, and the support has been.
So now it has been restored, but for many things, 482 was not available, and that power was also not there, 438. Therefore, writ petitions were entertained. Article 21, but here we permit entertaining of 482.
Court, what it should be actually the inherent power of the court, High Court under, to do range of justice or. But Since there is an undue delay in the investigation of the case, so my rights under Article 21 have been violated. So only on that ground I am before your lordship.
You just obtain instructions, what has happened? Can you say P. Cooperative Counsel for the petitioner? As well as Mr. Sharma, Mrs. Sharma, and government advocate appearing for the respondents. Issue of penalty open. And before issuance of notice in the matter, the learned government advocate shall obtain instructions from the officer in charge of Karimganj Police Station regarding progress of investigation in Karimganj PS case number 1099 of 2017, lodged on 2/12/2017. Under section 306 of the IPC.
Double treatment.
How much time? How much time? So it's a date.
22nd, 23rd, brother.
22nd or 24th, make it.
24th.
23rd is a hearing day, so you want to save that day. 24th? Okay, 24th. 4/20/24. That's better. Before that, you say the government entity is permitted to send a downloaded copy of this order to the officer in charge of Karimganj Police Station. Or should we direct, instead of OC Karimganj Police Station, should we direct the superintendent of police to?
Well, let it be the OC to respond. He is a party, madam. Let him.
No, I'm asking you because on the last matter, they did not respond to you. That's why I'm asking.
Both, my lord, both in that case.
It's one of the 3 and 4 people. So then the police, Karimganj, as well as officer in charge of Karimganj Police Station. Because then the OC will respond. Once we are issuing notice to superintendent of police. Somebody has died, otherwise I would have closed it, but somebody has died. Lady has died. That's why.
Item 9.
Please, Lordship, my lord.
Similar matter was for study, my lord. That was WBC 3-1. I got order, same order made it pass, and family also same. That day, son has done today, wife is the. 20%. এটা লাগিব নেকি? Last order.
But my lord, in terms of Order passed by this order, but maybe dispose also.
That they also submitted, this cannot be disposed of, said lordship, pass an order, say, same matter, same family, same reason, let it notice
So
go.
disposal at the motion stage without notice to
No, that's
the
my lord.
respondents are not doing.
Development, a new development has come occurred, my lord. ঠিক আছে তো এনেই কি হবে সেইটো কোৱা কথাই নাই সেই মতে লোৱা তোমাৰ সেইদিনা লৰাই কৰিছে ডিভাইচে কৰিছে একেই মেটাৰ একেই কথা
Same order, right?
Respondents also same, my lord.
So same.
Same. No difference.
We are fixing the same date. List after 4 weeks. Same.
Same, my lord. বিমান আছে বুকে দিবি তেতিয়াহে পইচা
Sir, please give it to them. So just a moment. Your presence, I'll just record, I forgot.
Lordship is making it returnable 4 weeks. Lordship.
No, just your names I forgot to write. Well, that's it, then I'll miss it.
I am for respond number 6 and 8.
I'm for
Number one,
I'm for 4 and 7.
CGC,
Did you see?
you know the same name, SKBD? SKBD CGC, for one. This is V. Zarika, and I standing counsel for respond number 2. Mr. V. Chaudhary.
Or 3 and
Oh, same.
rest are
Same names.
4 and 7.
Same names.
Like,
4 weeks.
Item 10.
We should notice here.
I am raising maintainability, my lord, in this petition.
No, here you would not be able to maintain, because the girl is missing.
yes, that's it.
But so far as he is also written that there is divorce proceeding and all these things, whether the same, this girl is same one or some different, my lord. If he is missing, then how come these proceedings come, my lord? I could not understand.
Divorce proceeding was initiated before missing lordship.
She's saying that the daughter is missing.
My lord,
She's saying that the daughter is still missing.
still missing. I can have the instruction stage of investigation, my lord. In otherwise, my lord, as per Sakiri Basu's judgment, my lord, it is the jurisdictional magistrate to whom he has to approach, my lord.
It is okay, but once it is missing,
My lord, then I can have an instruction on that, my lord. What is the stage of investigation at least at this stage, my lord. But so far as his prayer is concerned regarding reconstruction and regarding constitution of another SIT or CID, my lord, proper investigation, properly, it will be before the magistrate concerned, my lord, as per Sakiri Basu. This court,
no, Sakiri Vasu does not permit you. There is
to
only
my
one.
knowledge, if any lacking, my lord, in case of any investigation, my lord, so far as I remember.
Sakiri Vasu. You're right.
Sakiri Basu is a 2007 judgment, Lordship. After that, in 2021, Dr. Noresh Kumar Mangla and Amita Agoral case is there, Lordship. And this honorable court has recorded both the cases in this judgment, Lordship. And after that, send the matter to the CBI, Lordship.
Case number 3.
Paragraph number 6, Lordship.
This case is related to extremist violence, my lord, so far as I remember.
But FIR was registered under section 365 only, Lordship, and in this case also, the
It
FIR was
relates to
registered under
extremist
365.
violence, my lord. I could remember the case.
And paragraph number 12, Lordship.
Facts are slightly different.
But Mr.
AD Chaudhary.
AD Chaudhary, counsel for the petitioner. As well as Ms. M. Bharmat and Government Advocate appearing for the respondents. Next, Government counsel for the petitioner has cited the case of Dr. Naresh Kumar Mangla, NARESH, Kumar Mangla, MENGLA, versus Anita Agarwal and others. Order dated 17, judgment dated 17/12/2020. Passed by Supreme Court of India in criminal appeal numbers 872-873 of 2020. And case of Chaisodi, AISODI, Hausen, THAOSEN, alias Chaisodi, JAISODI, Temprai, KENPRAI. This is the state of Assam and others. It is the same. Next paragraph. Be that as it may, keeping the issue of maintenance open, the court is inclined to because the government advocate to obtain
Status of Silchar case, my lord. It is page 32, my lord.
of Silchar PS case number 2558 of 2022.
2552/22, I think.
2558.
2558
8,
of 2022.
Page
under
32.
section 365 IPC. From the officer in charge of Silchar police station. Next paragraph, the Government Advocate shall send a downloaded copy of this order to the officer in charge of Silchar police station. Who on receipt of the same shall provide a status report of investigation to the Government Advocate. Full stop. It is made clear that in order to maintain confidentiality of the status report of investigation, such report will not be made a part of the record. How much time? Give us a time.
On reopening, if lordship is pleases, because we are having 2-3 days left,
20
my lord.
22/4,
I'll try.
22/4/2020.
The direction to be rotate to be DGP also, my lord, along with officer in charge. I have to rotate from
So DGP
2 and 3, my lord. It will be better.
2 and 3. DGP, Director General Police, Assam and
22nd, my lord. Obliged.
Obliged, not. You take back this.
My lord.
On the next date, you place this judgment. You be prepared, this may not be applicable.
So far as
Have-
the 1000 cases, I
I've
have
read through in the meanwhile. This may not be an appropriate, what you call binding precedent for us.
With the instructions now, I will
No,
apply.
no, not that. When you're citing a case, I'm telling you that
Yes, Lordship.
you be prepared with this.
Yes, Lordship.
Item 12,
The petitioner is a holder of the Miadi Patta land.
Notice,
At page 17 is the Patta.
we'll issue a notice.
Initially,
Mr. B.P. Bora, counsel for the petitioner, also had Mr. H. Sharma, go ahead. Additional senior government advocate appearing for respondent number 1. Mr. J. Sutyal, and standing counsel for the KAC, representing respondent numbers 2 to
2 to 5 by dot.
2 to 5. NHAI. Mrs. Bora or Mr. Barwa?
RK Talukdar is also there. RK Talukdar, NSA DCL.
Arti Talukdar. Or Mrs. Bora?
For respondent number 1.
No, or Mrs. Bora?
6 Ranu Bora or RK Talukdar. Anyway.
Mrs. Bora was there.
Highway authority is different, my lord. NSA DCL is different. Respondent number 6 is the NSA Highway Authority, and the 7 is the NSA DCL.
Lordship, I can immediately give a copy. Lordship, my record.
Okay, this is R. Bora, and it's 20% for respondent number.
Yes, I have a
6.
contact on highway as well.
7 is Talukdar.
And it's Arti Talukdar, and it's standing counsel for NHI DCL,
NSA DCL.
our respondent number 7. The petitioner claims that the respondent authorities have occupied their land and demolished their 3-story building. Despite withdrawal of the eviction notice. And without acquisition of the land. The present writ petition has been filed under Article 226 of the Constitution of India. For directing the respondent authorities to compensate the petitioner. To pay compensation to the petitioner. Right? Consideration notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned state and departmental councils in course of the day. Next, review of the serious allegations made. The respondents shall file their affidavit in opposition. Next paragraph. The registry shall reflect the names of SC, NH, AI. Who are listing the matter next. Just after 4 weeks.
time being item 4.
Yes.
What is the matter relating to section 16(4)? What's the SLP as a pending before the Honorable Supreme Court?
We issue notice here then, because it has to be done.
There is an impugned order, Lordship, the recovery perhaps may not be enforced. Page 44 is the order, Lordship.
Heard. Mr. D. Saraf, counsel for the petitioner. Also heard. Mr. V. Chaudhary, standing us for the Union of India will be there.
CGC.
Ranjit Dev Chaudhary, इसने में भी record होता है.
Mr. R.K.D. Chaudhary, DSGI appearing for respondent number 1. Mr. V. Chaudhary, standing counsel for state GST, representing respondent numbers 2, 4, and 5. This is M. Burman, government advocate appearing for
Each only will be 246, Lordship.
No, this is number 2 is finance taxation. You are appearing for number 2.
He can appear.
Lordship, 2,
4 and 6.
4, and 6.
Lordship.
Mr. S.C. Cal, standing counsel for respondent numbers
5.
3,
3 and 5.
3, and 5. Government appeal is not there. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the show cause notice dated 11/9/2023 and the impugned order in original dated 24/1/2023 issued by the Assistant Commissioner CGST and Central Excise. Jorhat within bracket respondent number 5. Next paragraph, the option will understand standing for CGST submits that the issue raised in this writ petition is sub judice before the Supreme Court of India.
SLP C 282703.
This one we don't qualify to. Next one, with the resignation. Issue notice to return over in 4 weeks. Requisite extra copies of the writ petition is out on the Granite State and Department Council in course of the day. Next one. As the issue is stated to be subject for the Supreme Court of India, the as an interim measure, the court is inclined to provide that till further orders of the court, the original the order in original dated 24/11/2023 shall not be enforced.
Deeply obliged, Lordship.
So this issues are coming up again and again. That's why I'm again asking you. You want to pay the original under protest because the interest will continue.
Lordship, they are not in a position.
Okay.
I had discussed it with them after
No, it's
query of
okay,
your Lordship.
because this matter came up and therefore I am being cautious.
I discussed, I took it up seriously, Lordship. Obliged.
Because the revenue interest may not be later on
Very exorbitant.
it will create a problem.
Supply item 39.
My lord, the private respondent number 4216 was damaged in my house engaging a JCB, and I
Just a
filed an
moment, just a
FIR
moment.
at page 11, my lord. No action has been taken thereon.
You file a complaint, read petition, I am not entertaining. I'll be closing this with liberty to you to approach the jurisdiction magistrate.
156.3. Lordship.
But I'm attending only on next Wednesday, my lord. I've written. They are trying to arrange.
You see, there is a court of the magistrate.
Yes.
Can you tell us why it is there?
This is a matter of approach for 156.
It's only time taking. That is why I have approved your lordship. On the next Wednesday itself, they will make a prayer place for it on my left. Only
On
some direction
the-
is given to
No,
the
no, no,
SP.
no, we will not convert this court into a magistrate's court.
Lordship. That's
That
right.
we are not doing.
Then it may be allowed to withdraw.
But Mr. Anej Mazhabihal and counsel for the petitioner. And Mr. Alex Sharma and additional senior government advocate appearing for the respondents.
1 to 3.
Respond numbers 1, 2, and 3. Next part. By having this repetition in the Article 226 of the Constitution of India, over the grievance of the petitioner is that his brother had lodged an FIR on 22/2/2024 before the officer in charge of Badarpur Police Station to the additional superintendent of police. However, the case was not registered and no investigation was initiated. It is projected that on the that the private respondents have dispossessed the petitioner and his family members from the from a plot of land measuring 3 bigha and have started construction of an Idgah, IDGAH, over his land. Accordingly, the petitioner has prayed for calling a report and directing the state respondents to take appropriate action and to direct the respondent numbers 4 to 16 to maintain status quo in respect of the land of the petitioner. Next one, the Learned Additional Senior Government Advocate has raised the issue of maintainability. Next one. We find that in the event the police does not register a complaint, the petitioner is an aggrieved person, has the liberty of making a complaint before the Superintendent of Police under section 154 within bracket 3 CRPC, and even if it does not yield any satisfactory result, it is open to the aggrieved person to file an application under section 156 within bracket 3 CRPC before the learned magistrate concerned. Full stop. Under the scheme of Criminal Procedure Code, we do not find that the magistrate cannot issue a direction for registration of an FIR or for a proper investigation to be made. And you also find that the magistrate is amply empowered to monitor the investigation and to ensure a proper investigation. The next part of the Criminal Procedure Code also contains provisions by which the suspected offenders may be directed to maintain peace and for the appropriate court to initiate proceedings under section 144 and or 145 CRPC. Next, therefore, as the petitioner has alternative remedies available to him, the court is not inclined to entertain this writ petition, and therefore this writ petition stands closed without issuance of notice on the respondents. Next, either as it may, the petitioner would have liberty to avail alternative remedy as may be available to him in accordance with law.
So I'm telling you the order dated my lord
Just a moment. What I said, you're not inclined to entertain this writ petition. At that place you write. But I have stated, court is not inclined to, I have stated somewhere, no, don't write. I have stated somewhere that the court is not inclined to entertain the writ petition. At that place you add. In this regard, the court is guided by the dictum of the Supreme Court of India in the case of Sakiri, SAKIRI, Vasu VASU versus State of UP and others. Within bracket 2008, that was 2 SCC. Within bracket 2008, bracket close 2 SCC 409. Yes, item 40.
May it please your lordship. Lordship, I am telling the order at page 75, my lord. Well, the last date of issuance of order was 31st of December 2023, my lord. And it
Page.
page 75, my lord. Before that, I'd like to take your lordship to page 44, my lord.
Yes.
My lord, here, my lord, by this notification, my lord, the last date of issuance of order under section 7310 was extended up to 31st of December 2023 for the financial year 17 and 18, my lord. That means, my lord, the last date of issuance of order was 31st of December 23, my lord. Now, lordship will find it page 75, my lord.
Yes.
The order has been passed on 1/1/2024, my lord.
Yes,
But it is beyond jurisdiction, my lord. The time limit was up to 31st of December 23, my lord.
we will issue notice. But Mr. R.S. Mishra, counsel for the petitioners, as well as Mr. V. Chaudhary, Learned, standing counsel for the state GST,
Yes. For the response.
appearing for all the respondents. So the Learned counsel for the petitioner. Has referred to the notification number 09/2023 dash central tax dated 31/3/2023 issued by the Central Board of Indirect Taxes and Customs, Government of India, by which time limit specified under section 73 within bracket 10 for issuance of order under section 73 within bracket 9 of the Central GST Act for recovery of tax not paid or short paid or of input tax credit wrongly availed or utilized, relating to the period for financial year 2017-18 was extended up to 31/12/2023. Full stop. It is projected that second paragraph. It is projected that the impugn order under reference number, you find it at page 75, pencil mark, dated 1/1/2024, was passed under section 73 for the financial year 2017-18. Accordingly, it is submitted that the said order is barred by limitation. In the previous paragraph, where I said extended up to 31/12/2023, you add there. It is also projected that the state GST has adopted the said notification dated 31/3/2023. The next paragraph again. Issue notice returnable in 4 weeks. No, just before that, accordingly, by filing the petition under Article 226 of the Constitution of India, the petitioner is sealed, said impugn order dated 1/1/2024, passed by the Deputy Commissioner of State Tax. Party B. From Assam. His respondent number
3, my lord.
Within bracket, respondent number 3. Issue notice returnable in 4 weeks. Requisite extra copies of the requisition is served on the landed standing counsel for the state GST within the course of the day. Next paragraph. In view of the projection that the order is barred by limitation as an interim measure until the next date, next returnable date, it is provided that and next date of listing, it is provided that the order passed under section 73 of the CGST Act dated 1/1/2024. You also give the numbers from page 75 dated 1/1/2024 shall not be enforced. Next, the petitioner shall produce a certified copy of the order before responding to the plea. List after 4 weeks.
Deeply obliged.
41.
But they are telling the notification lordship was for similar orders in item 41.
41.
40.
Where is that?
I'm providing.
Show it to Mr. Pyal.
I know.
You know that. Okay. You participated in the process?
No, my lord. I requested for providing opportunity of personal hearing, my lord, that was not given to me, my lord. Page 50, my lord.
Page
50. It was my request for providing the opportunity of hearing, my lord. CL number 7, I have opted for personal hearing, my lord.
this same author, huh? Will be new paragraph. B. The Land Council for the petitioner projects that on receipt of a show cause notice dated 28/9/2023, the petitioner by a communication dated 20/11/2023 addressed to the Assistant Commissioner of State Tax, Mangalday-1 had requested for time to give a show cause reply and also requested for a personal hearing. However, it is projected, however, it is projected that without giving such opportunity, the interim order bearing number page 52, pencil mark, dated 30/12/2023 was issued by the respondent number
It's
by
respondent
the
number,
Assistant Commissioner of State Tax, Mangalday 1.
Respondent number 5, my lord.
Respondent number 5. As an interim measure, it is provided that as similar issues are being examined by various courts of the country, the court is inclined as an interim measure, that the recovery of the amount assessed by the impugn order dated 30/12/2023 shall not be enforced. Did we say 10/5? Same day we are doing?
Yes.
10/5.
One more thing, my lord. My lord, in this case, they have recovered some amount at page 56, my lord. They have debited the ledger from our portal, my lord.
Page
56 and 57, my lord.
56. Then you say,
Not sure. This, my lord, in the electronic case ledger.
earlier statement, we just add, it is also submitted that in the meanwhile, the respondent authorities have also recovered some amount from the credit ledger. It's credit ledger, right?
My lord, credit ledger.
Credit ledger of the petitioner. Then no further amount should be realized. Instead of no recovery, no further amount should be recovered. Okay.
Deeply obliged. And item number 42 is also similar, my lord. The only difference is that, my lord, here financial aid involves 18-19, my lord. Item number 42, my lord, it is also similar, my lord, as of item 41, my lord.
You make that correction with the order and give a photocopy.
Deeply obliged.
What difference is it? What did you say? Different financial exchange.
For admission, item 14 to 17.
For 15 and 16. Okay. 15 minutes, I do not finish minutes. It will be allowed to withdraw. Only 15.
You're pressing only 15.
15 wants to withdraw.
Withdraw.
He is not pressing item 15.
15 you want to withdraw.
Withdraw.
Okay, please become 15 say. For Mr. A. Rashid, and counsel for the petitioner, as well as Mr. D. Nath, and have senior government advocate appearing for respondent numbers 3 and 4. Rules for others. As government advocate, you will be appearing for respondent number 1,
1, 2, 3, and 4.
1, 2, 3, 4.
5 also same. 1 to 5. 1 to 5.
None appears on call for the other respondents. Numbers 6 to 15. Next paragraph. Upon instructions, the land counsel for the petitioners is due to withdraw this petition. This was the said here, comma, having not objected to, comma, stands allowed. This is dismissed on withdrawal. 15, yes.
16, Lord, this is regarding.
Item 14, who is for item 14?
14.
Yes. Okay. No, it's okay. I'm just wanting to know the lawyers. You are there, then you please continue. Item?
16, there is similar order passed by all courts in the similar.
It can be disposed of in that line.
In the line.
Yes.
Which?
Item 16.
This is the order, Lord.
Where is the order passed?
Copy has been given.
Copy I have given. I passed. Either passed by Honorable Justice SK Medin. Chain market. Same Miller. Check. Only petitioners are separable. Paragraph Miller 6, Your Lordship, you can see.
What is the factual position there? How many houses, how many shops are left there?
My instruction that we are not selected. Some other person they are selected without legal procedure. I have given an institution. Someone will have given backdated petition file and someone will have affidavit file without showing before the magistrate notary. I can see some Your Lordship, some only some instances. No,
How many rooms are there? Number one. How many rooms are there?
Well, the
total rooms, only my lawyer will be able to say, but my instruction will have more than 100.
applications were more than 380. 380.
Yes.
And when the rooms, it is
104 something.
No, but in the meanwhile, several applications orders have been passed.
Lordships.
Now, is there any room left for consideration? That's what the question is.
In fact, Lordship has directed the Deputy Commissioner to look into the entire thing. And it's a big question.
No, if he had done it, the petitioners would not have been here now. This order was in 2020.
No,
we are 4 years down the line.
No, that process has not been completed as per my instruction.
Even after 4 years.
No, because in some other cases, some stay orders are there. So many cases are there, Lord. In one case, direction has been given, and the inquiry process should not be completed.
You can always request the registry to resolve this matter, and then there will be a common order.
That's true. That will.
And
otherwise, what happens is that you are creating a hurdle for yourself. There will be conflicting orders. You see, their cases will be considered. But how many cases can be considered? There will be only 100.
But in fact, one person he applies for 3-4 occasions. That is, but some common petitioners are also there. That is an aspect, Lord. Lordship, in that case, Lord, I'll just.
Then we say that notwithstanding this order, they can. They can examine
verify the claim.
Eligibility of all the applicants.
Yes. That will do. In fact, that will be.
Yeah, otherwise,
that will solve the problem.
People who come last do not get the shops at all. They will say then the authorities will say that we have already considered. 100 people are already there. Then there's no space.
No, in fact, what has happened here? All of them, most of them, in fact, along with others, they have already applied for the shop. But pending consideration of the authority, they have approached the honorable that on apprehension.
ultimately the authority, because of the stay order, they are not in a position to take any action. Some have given some amount, advance amount for while applying or not.
You see, that's what the anxiety is.
Lordship.
Then with that information, if I'm passing an order, this order would be otherwise non-compliable because of some stay operating somewhere.
So that these four cases are taken together, and if any other matters are there, let us have on a fixed date, I'll give the list, and I'll take the instruction and give the list, so that
You make a mention, we'll permit that
Yes,
to
yes.
be all the cases will be listed.
yes, yes,
together.
yes, that will be better.
Probably my 2023, your lordship also passed on in one case on order. Similar.
Oh, I understand, but you see, if we pass an order and still it will not be implemented, here is a case where the direction is for 45 days. This was passed in 2020.
20.
And still the shops have not been allotted. So is there any purpose will be solved by passing an order which is not compliable?
Mine student will have some petition will have who I also did with some cases, and those are will have disposed.
No,
of
I
by
don't
the-
want the orders of the court to be non-implementable orders.
True, my lord.
We'll just make a recording here and
Yes.
permit you.
Yes, my lord. I'll submit.
Uh,
But in fact, in item number 14, today in the list, 8454 of 22,
Yes.
but a notice was issued by the executive officer that you stop construction because some construction work was there and some complaint was there. But that has been stayed by the honorable court, and it is pending, my lord. And so many orders are there. We'll do that, my lord. We'll give the list, entire list, and so that entire beds of cases can be considered.
That can be disposed
Yes,
of
yes.
in this shop.
That will be good.
In this
Lordship,
order, in this item 16,
This is item 16.
WPC 3213 of 2020. Here
Yes.
is, right. But Mr. A. Rashid, on counsel for the petitioners, and Mr. D. Nath Leonard, senior government advocate appearing for the respondent numbers
But in item number
16.
16, somebody type on it. But for 1 to 5 again.
1 to 5.
Yes, madam.
Is that you're appearing for someone? You are with him.
No, we are together, madam.
Next one. The learned counsel for the petitioner has produced a copy of order dated 7/1/2020, passed by this court in WPC 6786 of 2014. And it is submitted that this petition can be disposed of in light of the said order. Full stop. Next one. On a query of the court, the learned senior government advocate has submitted that there are more than 100 rooms for allotment in the newly constructed multi-story business center of Lanka Municipal Board. So, however, there were 318 numbers of earlier Vita holders, and there are several petitions pending. And in view of stay order operating in some of the matters, despite order dated 7/1/2020 passed in WPC 6786 of 2014, the matter could not be finalized. Next paragraph. Taking note of the fact that till date, the order dated 7/1/2020 passed in WPC 6786 of 2014 has not been complied with, despite direction that the inquiry as ordered therein should be completed within 45 days. The court is of the considered opinion that it would be appropriate that the learned government advocate, senior government advocate shall provide a list of all the cases pending with regard to allotment of shops in the new multi-story business center of Lanka Municipal Board. So that a common order can be passed. Which would allow the respondent authorities to finally take a call of allotment of shops.
Yes.
Therein. Next, learned senior government advocate is given liberty to make a mention for listing of the batch of similar cases. So accordingly, the matter stands deferred today based on
22
Hold
April.
on 29th,
29th.
Ninth. Or 24th.
We made last day 26th.
Lot.
26th.
Lot.
26th April. Take back this order. Yes, you are
Item 14, same order.
same order. Okay, item 14 is MH. Mazur Viran. Same order. In this item 17.
Lot.
17 by
17 by the advocate is different, matter is same. Item number 14 and item number 17 challenge are same.
17 none appears on column. It's same order. Okay.
Lot. Hold on.
Item 18.
Lordship, I have taken the consent of the other side, your Lordship. I pray for adjournment of this matter.
Pardon me?
Adjournment of this matter, your Lordship. Mr. H. M. Chaudhary is appearing due to some personal difficulties, could not come up to the court today.
Just a moment. Yes, you have any information why he did not get the Adhaar card?
No, my lord, in para 5, at page 24, it has been mentioned by the department that her issuance of the Adhaar card has been put on hold. My lord, I need to take instructions in this matter. My lord, kindly grant me just for a very short time, my lord. In the meanwhile, I will get the instruction from the department.
Both sides are represented. Your opinion is CGC?
CGC, Central Government.
The General Counsel for the petitioner prays for adjournment. Mr. B. Dekatan and CEC also prays for adjournment to enable him to obtain updated status of the issue relating to the issuance of Adhaar card the petitioner. Next. Paragraph. It's employment and government educate appeals for respondent number
5.
2 and 5.
And 2 and 5.
Just after answering.
General
Give me a date.
administration is my state of standing council, my lord. Nayak and Upon is there. Then
For,
Upon is
for
there.
2.
2, my lord. I am for 5.
For 2 Mr. P. and so 5 Mrs. Burman.
Their name.
List 1, give a date after application. Yes, item 19.
19.
Here is, I may allow some time to file my response also. My matter relating to delay in filing appeal also. Their contention is that it's covered by the Supreme Court that judgment. But our contention is that that period is already over and the authority has no power as decided by the Honorable Supreme Court in different cases.
No, but there is an issue. We'll require a full-fledged hearing on this point.
No.
Be otherwise prepared. You see, you have that suo motu 3.
Yes,
order?
yes, my lord. If there is, my lord, at page, my lord, 70.
70. You see, come to para 8.1.
5.1. The order dated 23/2022.
Oh, sorry, 5.1. Now, you see, I'm thinking in line of limitation in otherwise in available in the schedule of the Limitation Act. Correct. Before I read this, the idea which is coming to the notion which is coming to the mind is number 1. For the period when this order is operating, that is 15/3/2020
till
28 to 2022 shall be excluded. So this exclusion would amount as if the court was closed. In civil, in the High Court, when you come in the vacations, it's closed.
Yes.
So therefore, you get an extension of limitation. Correct?
Yes.
So that does not operate. So let us assume that Mr. Gogoi, we need your assistance also. Just for whenever the next date you be prepared. I'm asking you because I find you that you are working hard on legal study. That's why. This suo motu 3, question of interpretation is coming up. 5.1, before that I'm just explaining the idea which, notion which is coming in the mind is, just like vacations here, when you come to High Court, file an appeal, there's a vacation. So that limitation under section 14 gets extended. Correct. So as if during this period, the limitation is not running. Now this suo motu 3, paragraph 5.1 says 15/3/2020 to 28/2/2022 shall stand excluded. Now this exclusion is something like that in the court when the vacations are there. So it means that the court is closed on that day. But under the principles which we are accustomed, on the reopening day, you will have to file it. Correct? So if that limitation is closed, within that period, you will have to file it. Now the question of interpretation comes.
What's it probably 2?
Number 2, consequently, period of limitation renewing so and so shall be available. That means, as on 3/10/2020, let us, we are testing it. Let us say somebody is wanting to file a suit. For suit, the limitation is 3 years. Now, if we read this 3, as well as
during the period.
2 and 3 together, last three lines. In the event actual balance of period limitation with the 1/3/2020 is greater than 90 days, that longer period shall apply. No, therefore, to file a suit, you have 3 years. Now, this is how many days? 15/3/2020 to 28/2/2022. Let us say it is roughly 2 years.
About 2 years.
Roughly 2 years. Now, the limitation to file a suit is 3 years.
Whether it will be in addition
So
to
will it mean 3 plus 2, 5?
5 years.
Correct. It should not mean like that. Normally, the interpretation should have been that the only for this period you get you get that benefit. So if we apply that principle, which we normally follow, that it should be on the after the vacation, it will not run, but in the reopening day you should file it. Then we understand. But this is a concept which is coming to my mind occasionally. That can somebody get
Another 2 years.
2 plus 3?
2 plus 3.
That can.
No, but it is
Apparently,
Otherwise, lordship, probably lordship, in that particular period, if the limitation is run lordship, then lordship it will be.
no, but 1 and 3. That's why it appears to be inconsistent. You see, 1.
Lordship.
one, yes,
1 is so and so shall stand excluded for the purpose of limitation.
there is a conflict
So
between.
therefore, my concept is that this is a period where the court is closed. Therefore, reopening day you will file it. But come to 3, in the event actual balance period remaining with effect from 1/3/22 is greater than 90 days, that longer period shall apply.
There is a conflict between 1 and 3.
So therefore, somebody says that my limitation was during that period. So after that, I still get that period of limitation.
And again, he will get benefit of 2 years.
You get the benefit of 2 years plus additional period of limitation of 90 days.
That cannot be, but
I don't know. This is what is appearing.
apparently it look like.
In one of these cases, in one of these days, this
Probably if some high courts have decided, I'll place that judgment.
for academic purpose, because
Yes, no, lordship, it is hearing, because every day the appellate authority come across this type of cases.
so somebody is in default. Did not
Lordship-
file within before the expiry of limitation. Says that my 1 day is left out. So this 1 day falls within on 16/3 instead of 15, or it falls on 15. Therefore, for 1 day,
He will get.
he gets 2 years plus 3 years of limitation again.
Yes.
Because 3 says, notwithstanding actual balance, the period of limitation remaining with effect from so and so is greater than the longer period shall apply.
Longer than 2 years.
I don't know.
No,
That's why I'm asking you.
Apparently, yes. I'll address.
That's why I'm asking you.
It's a fix
Because-
after pre-vacation. We'll address.
Because you may interact with the senior law officers of the country, and then they can guide you because you will have access to them.
But this point came for consideration before different high court.
I have not found
Not
any decision where this, nobody would have,
not exactly this, but
the
extension of
second
time.
part of paragraph 3, I have not found any interpretation.
I'll address your lordship.
Both sides are represented. On the prayer made by Mr. S.C. Kyal, I mean, standing also for CGST, the matter stands adjourned. We are going to file affidavit in opposition to the matter. List after
vacation. Due vacation.
List after 3 weeks. Interim order passed against stands extended to the next day of listing.
Much of
Lastly, because you do some legal research, that's why you are
I
asking me. I'll take a short break and come back.
My son died in a road traffic accident. I have made representations
Yes.
Lordship, as per my instructions, Your Lordship, there the proposal has been sent by the Deputy Commissioner to the Revenue Department. And Revenue Department has already processed it, but because of the election duty, the money could not be dispersed.
Yesterday also you passed an order. Yesterday also you passed an order.
Yesterday also 2 cases were like that, Your Lordship. Within
Case
2
numbers.
weeks. Yes, Your Lordship, I have them. Yes, Your Lordship.
Same order. Mr. Adhaar for the petitioner. And Borgore, standing counsel for the Revenue Department, and this M. Burman and Government Advocate, and this
I am responding to
M. Burger for respondent number 2.
If you will like give the sheet of paper, I will write and give these numbers.
Just have it, you'll write it.
One was, Your Lordship, WPC 4037 of 2023, Srimati Shanti Lata Nath at Shanti Nath versus State of Assam.
The serial number yesterday.
Yesterday, this one is, this matter came on 2nd of April, 3rd of April, Your Lordship, item number 24.
Same order.
And there was
It's
another.
okay. One would be okay.
Yes, Your Lordship.
Take off. Same order we are passing.
Yes, Your Lordship.
He's giving them some time to inform us. That when they are
And one of the case, 3 weeks time was granted, Your Lordship.
okay.
Obliged, Your Lordship.
Item 21.
21.
I appear on behalf of the writ petitioner lordship on 19/4, on 19/1/2024 lordship, the respondents were supposed to file an affidavit. It's not yet filed. Your Lordship.
May it please, Your Lordship.
Yes.
Lordship, we have received some instruction, Lordship. 2 of the petitioners, they have agreed, Lordship, for negotiation, Lordship. So we'd like to file our affidavit, Lordship. 4 weeks time may be granted, Lordship.
Enough time has passed, Your Lordship. Maybe a short date can be given, Lordship.
Negotiation is still going on, Lordship. Two petitioners has already agreed, Lordship.
But there's an interim order which is operating.
Yes, sir.
My lord, these are all Pata land. They want to just grab it, my lord.
No, it's not that. These few days we are getting those matters.
Yes.
What is happening is that this alignment on those things, some land comes in between, they can't identify because they go by that, they go by their own drawing. At times what happens is that you have the curvature of a road. Incidentally, it doesn't go straight, it curves.
No,
Those things
that's a
happen.
different issue, my lord. If in a given case, that is the situation, then they have a right. But generally, my lord, they claim that 50 feet from the center line. That is neither here nor there. That is to the extent of the government land is that they can do whatever it like. But if they want to take private land for widening of the road or construction of the flyover, they can still do that, but they'll have to pay us compensation. That's the case. And it's a Pata land. Where is the question of invoking Rule 18(3), my lord? Rule 18 has been invoked. It's not Sarkari land.
Also, they are represented, including Mr. K. N. Chaudhary, the senior counsel for the petitioner. Next, the senior counsel for the AAC pays for some more time to negotiate with the petitioner.
Petitioner has already been agreed. They have received a compensation, my lord. The other compensation for settlement in respect to other petition is going on, my lord. Lordship may grant sometime and will file the affidavit regarding these 2 petitioners, my lord.
No, my lord, what I fail to understand is what compensation you are paying. Have you made a award under the Land Commission Act?
No,
There's outright purchases
if they are negotiating and the
Purchase, outright
As
purchase.
far as those who agree to negotiate, I've got nothing to say. But as far as the client whom I am representing for the present, my lord, they are not for negotiation. They
says that
That's for number 5, 6 and 7, my lord.
I was just now they have said, my lord, we'll inquire. But yesterday we have received phone call, my junior has received phone call from other petitioner. They said we are not doing anything. They also said that they heard that one or two petitioner are in, engaging themselves with the guard department.
It's okay, we're not believing you.
Yes.
Just now I have
Somebody is
received
willingly
order.
doing it, I have got nothing.
They have all, that they have received a compensation on 30 March, my lord. Two petitioners, my lord. So I have received an instruction today, my lord.
So, two of the petitions, not all, two of the petitions. Just one. Next, maybe there is matters was adjourned today. Interim order passed today stands extended. List after.
After 3 weeks, my lord. First week
After
of
3
May.
weeks.
First week of May. Any day.
Yes, yes. I have no.
This one, 1/5/2024.
Okay.
Deeply.
Item 22.
May I please, my lordship, kindly grant 2 weeks of time?
Just a moment.
This is a matter of for the appointment of arbitrator under section 11(6) and 15, Lordship. Earlier, the arbitrator was appointed by this honorable court, and that award was set aside by the district court, and as well as this honorable court, the judgment at page number 6, Lord.
It's okay, she is wanting time.
Lordship, they have already asked for so many adjournments. It is being, arbitration is already delayed.
No, this is first date, they are taking a time. On 13/3, we issued a notice of motion.
This is, okay,
No, no,
right, that was the other case. Okay, please. Then,
Both sides are represented. On the player made by Ms.
A. Sharma,
A. Sharma on behalf of
CGC.
the CGC. How much time you need?
2 weeks of time.
Lordship, one submission. Kindly, I have to come long with a distance. Kindly be given the 13th of May. I have to go Chandigarh back.
Okay, when do you want?
13th May, Lordship.
Okay, please file and does it 2 weeks time to file affidavit in opposition in the matter. Next, is agreed to by both sides. List on 13/5/2024.
Lordship, obliged.
But please file it because he's coming in petition person coming from Chandigarh. Correct? You give instructions accordingly.
Obliged.
23.
Lordship, I need some time, my lord. We already been communicated, but no instruction has been received till date.
Okay, the status is a status quo operating.
Lordship.
Okay, both sides are represented.
Interim order may be continued.
Mr. J. Hendrik Leonard standing counsel for the Revenue Department.
No, Lordship, I appear on behalf of the, my lord, that district, state.
As government advocate.
Lordship, my learned
Okay,
friend.
government advocate, please for some more time to obtain instructions and file affidavit in opposition in the matter. Yes, for revenue, you have anything to say? No. Ms. G. Hazarika, and standing counsel for the Revenue Department is present. So interim order passed at list and extended will be negated on the screen. Interim order of status quo passed on 1/3/2024 stands extended to the next date of the screen. List after
2 weeks.
list after 2 weeks.
Obliged.
24.
Wait, suppose.
But you see, he's in a difficult position. There's a lookout notice.
Lordship,
He's under lookout notice. There's a lookout notice.
Lookout notice.
look up notice.
Yes. If we get to give it on time, 4 weeks will be too much. We've already granted you earlier time.
Oh, taking section that the motion is says, Lordship, what the section C is not came, Lordship. As such, notice was issued on the last occasion.
Okay.
In the meantime, my lordship may pay some observation to not harassing the petitioners at the airport, Your Honor. Some observation is given, my lord. Otherwise, they have interrogated unauthorized by the respondent.
Where is the lookout notice?
My lord, they are not disclose anything to the petitioners in spite of the.
No, because you see, you were caught with the wildlife spices.
That is discharged.
No, but still.
But that is wrongly cocked, Your Honor, that in that case, my lord, petitioner discharged from the case. That is the order, there is the order, Your Honor. Lordship. Page 28, annexure D, Your Lordship.
No, you see, there are two things. Number one, in a repetition, to grant you an interim protection is a bit out of.
So I am not seeking any intent, I am just observing.
But what
something
observation?
that-
Observations can't be vague. In a repetition, I have to give a specific observation. What type of observation you need?
At least in the filing of the producing the report, my lord, petitioner may not be unauthorized harassing by the.
No, harassment is, you see, I look at you, it can be harassment. You can file a complaint that why the judge is looking at him, looking at me. He is not looking at 20 other lawyers sitting. He was looking at me, therefore it is harassment.
That is right, Lord.
So what sort of harassment?
So while they are
No,
entering.
I am not passing vague orders. I must understand my orders. It should be implementable. So what is harassment? I must understand.
They are interrogated 2-3 hours prior to entering the airport, Your Honor. That is why. But while we are asking why they are
Which day
interrogated, they are nothing said.
which day did that happen? We'll call for the CCTV footage.
They didn't provide
You
the
tell us,
CCTV.
you tell us on which day it happened.
My lord, there is so many dates, my lord.
Give one date.
After 4 weeks. New one.
But you are permitted to travel.
Yes, my lord.
You are permitted to travel.
Yes.
But Mr. S.K. Sinha.
NC Das.
Mr. N.G. Das, counsel for the petitioner. He submitted that petitioners is submitted that lookout circulars have been issued against all the 3 petitioners. And despite the petitioner satisfying the authorities. They are subject to lengthy interrogation at all airports in the country. Which is stated to be causing a lot of trouble to the petitioners. Who has issued the lookout circular? Where is that copy of the lookout notice?
Madam, there is no lookout notice. We have nothing to say by the respondents. They are saying, while the interrogated us, they are saying that there is a lookout notice against us. As therefore, thereafter we filed a RTI application. There are nothing to say in that RTI. In that article.
Where is your RTI?
reply. RTI page F your.
How it is submitted that when the petitioners have applied for
Annexure 30.
RTI information about such existence of the lookout circulars. Were not provided. On the ground that the information sought for pertains to Bureau of Immigration and Intelligence Bureau. Next one. In view of such allegations, the court is inclined to direct the respondents to file their affidavit in opposition positively within the next date fixed. Next paragraph. Mr. DC Varal and CGC praised for 4 weeks time to file the affidavit in opposition. However, the court is inclined to grant only 3 weeks time to the respondents to file the affidavit in opposition. Most of. In the event from the responding authorities do not want to disclose the reasons, the instructions may be provided to the CGC in a seal envelope. Next page, list on 1/5/2023.
Lordship.
Correct.
Lordship.
We are giving us 3 weeks time. If you can't file affidavit to disclose, then you give us
Lordship.
seal envelope.
Lordship.
Next, for the Lawrence CGC will shall send a downloaded copy of the order to the respondent authorities. So, timely filing of the affidavit.
Obliged.
Much obliged.
Supply item 43.
Please, your lordship.
Yes.
Your lordship will remember, might not be, accounts of the firm has not been allowed to be operated by the banks. On the last occasion, my learned friend was not there to appear for the bank. He is there today, madam. We have.
Yes.
My lord, I have filed a reply, two reply, my lord. One reply from the branch manager from Seniguti and another is my lord, branch manager. My lord, here is a case, my lord. This is a case of one of the my lord partner. This is a Pragati, is a partnership firm, my lord. Three partners was there. Among one partners, my lord, that is my lord, Paresh Kumar Gogoi made an application to, before the branch, before the branch manager, my lord, requesting to hold the accounts. There is a two accounts of the firm, my lord.
You
And
can get us the mandate of the operation of the account by 2 o'clock.
now, my lord, I'm coming, my lord. Then, my lord, what happened, my lord? When I reached,
Story we know.
Yeah.
They are asking you that what is do you have the copy of the bank mandate?
oh, what we asked the mutual consent letters, my lord, from the team partners, my lord. That letters we have wrote to the partners, all the partners, my lord. Kindly look into that page 49 annexure B, my lord, where we short this one.
Page
Page 40, my lord, here, my affidavit, my lord, annexure B. My number is 49. It's serial number. This affidavit filed by
No.
Malavipaga Das, my lord, Seniguti branch, my lord.
Something wrong. Have I been able to communicate what I want? Have you understood what is the requirement of the court? What did I ask you? What was the query of the court? What was the question asked to you? I asked you some question. You responded by showing page 49. What was the question?
My lord. Sorry,
So please have the habit of hearing first and then responding. Correct?
my lord.
I'm asking you, do you have a mandate of the parties to operate the account? If not, bring it at 2 o'clock. Get it on your WhatsApp.
That is not with me, my lord.
Get it by 2 o'clock. Otherwise, you are calling our bank manager. Personal appearance on Monday.
I'll try, my lord. Let
The,
me try, my lord.
the parties mandate to operate the account. Get me a copy of that
My lord.
at 2 o'clock.
Bless me.
Yes, 44.
Lordship, would you apology that in this case, senior counsel from Delhi on PC, my lord. So he is in Supreme Court, my lord, maybe at 2, my lord. Just 15 is left out for.
One more submission, lordship. Just now they have given a reply. So we have to respond. I haven't gone through it also. Let the matter be taken up on Monday, lordship.
Just a moment. Let me understand. There's a judgment already here. We find that there's a judgment already here.
It is like this, the learned single judge passed an interim order. Against it, the state went to the division bench, and the division bench set aside the learned single judge's interim order and requested the
There is a
next
division bench
bench
order.
to take up the matter
Just a moment.
from today.
Just a moment.
The operative portion will be sufficient.
Paragraph 32. 31 and 32.
Respondent command.
But Mr. Sekia,
Lordship.
para 31 says that it should be for final disposal today.
Final disposal today.
Mr. Sarania,
My lord.
if you're filing a reply at this stage, definitely they will need a time. But then there's a division bench order directing us to continue with the hearing. So therefore your reply either will have to be excluded.
One second, while I just trouble your lordship. My learned all senior friends are also here. With this case, I have been engaged. Now, I am the person who has made a complaint before the authority. And all the documents were submitted before authority. And we say before the authority that it doesn't follow the procedural order 1950. So it should be cancelled. A full-fledged hearing was placed. Legacy also, their legacy was supplied before the authority and they have come to a finding. Now, the matter was taken up by the learned single judge. An interim order was passed. Now your lordship has set aside. So at least we also want to give a short affidavit to the court. But otherwise, this will, it will.
You see, otherwise it would have been okay. But there is a direction by the division bench saying that it is listed for disposal. Now, under the circumstances.
What exactly is written, Lordship? May I read it, Lord?
Para 31.
Yes. In view of the above discussion, we are of the view that the impugn order passed by the learned single judge cannot be sustained, and same is therefore stated. However, looking at the urgency of the matter, we direct the registry to list the writ petition filed by respondent number 1 on 5/4/2024 before the learned single judge holding the roster for final disposal. We request the learned single judge to decide the writ petition expeditiously while hearing on day-to-day basis if required. So now the issue is, while disposing the matter, whether lordship will follow the procedure which are mandatory in nature. Tomorrow, I do not know in whose favor it will go. But for that process, suppose he wants to file an affidavit. I want to file maybe a response to the reply. If these things are bypassed, then that will become a ground for challenge in the next round.
But
isn't it, Lordship?
No.
These are fundamental principles of natural justice.
You see, as advocate general, you are correctly making a statement. We can't discount that. It is absolutely correct. But there's a direction by the division bench, and
that means what indicates here is that the matter may be listed today because the matter, this judgment was delivered yesterday.
Yesterday,
Day before yesterday, but it was this at
uploaded at around
4:15. The matter was reserved, and tomorrow during the course of day, the judgment was given to us.
uh-huh.
And if required so, kindly see the last. If required so, the day-to-day basis, if required so. Now, if the pleadings are not being completed, they file, we want to give, if required so, my lord. So at least that.
At least he.
I should at least, my lord, get the opportunity. I am not asking for a very lengthy day. At least I should get the
My lord-
opportunity, I made a complaint.
And now they are seeking adjournment, not we are seeking it.
I am not
No,
seeking
he's not
adjournment.
seeking adjournment. He's seeking accommodation of 10 minutes.
Not only for 15
But
minutes. my lord.
today's second half is very difficult because we have other programs also. To
Understand. But you
the
agree to a
Foundation
date-
Days program.
But you agree to a date.
Yes,
Yes, my lord, may I pray, my lord, submit, my lord, because this as per the direction day to day means maybe tomorrow also if court, my lord,
Oh,
otherwise it is.
that-
hereby
that-
means
that is- that is
Because
not-
in important matter, Supreme Court, even midnight also sits, my lord, even holiday also sits. This is a important regarding election, my lord, because last date of filing of the election 19th.
Yes. Your thoughts are very good. But incidentally, I am not permitted to fix my roster.
My lord, yesterday order has been,
I understand.
my lord, come to a knowledge of us, my lord,
Please
at
understand
around
my
3, my lord.
limitations. Please understand my limitations. I don't fix the roster. I am not the master of the roster. I am merely what you call soldier, foot soldier in the team of 24. We do what is destined by the master of the roster. Inside the court, I have a freedom, but I can't fix my roster.
My
You'll have to request the
my
Honorable
lord,
Chief
you-
Justice. If I have to
Division
take-
bench, honorable chief justice indicated, my lord, in the
No,
order.
no,
Maybe
he
there
did not
today.
say.
If requires, man, the requirement is there, my lord.
No.
Requirement is there.
No, you see. Please understand our limitations. I say
That
something.
day to day does not
saying
mean
thing-
that on Saturday or on Sunday, the court will sit.
If my lordship time is permit, my lord, there is no otherwise busy with
That's right.
other.
But if you have filed, that's why I say, your option is that if you have filed it, then he gets an opportunity of
My lord,
responding.
my lord, after getting information yesterday, I have last night prepared, today I have filed, my lord. So it was
Till now I
it was
have
19,
got-
my lord. It was the notice was returnable in 19/4/2024, my lord.
When
I
Mr.
supposed to
Sarnia-
file after view
Mr.
vacation.
Sarnia, when I-
Considering the emergency, my lord, I have filed.
Please, just a moment. Please always remember, I am saying for myself, with all humility at my command, when I'm making a statement, that means I have some
My lord, that I
some
understand.
background for which I'm
My-
making that.
my
I'll show
lord,
you that.
My lord,
Just give me 1 second. I'll show you that.
High Court rules, my lord.
Anasa pahle aji ek kori do.
আরে মই আজি এই চকুৰে দেখা হৈছো এইটো ৰিপ্লাই টু দিম
See, I am showing you this.
My lord,
Page 28, paragraph 14.
Pahle shopping mall pa.
Hajj.
That's my lord reply.
No.
regarding allowing your time for adjournment.
No. Okay.
Paragraph 14.
14.
No, everything in answer. That I have to gone through my lord, that High Court rules, my lord.
That's why when I'm making a statement,
My lord,
please
they
make
may,
sure.
if we proceed to the also, they may reply, my lord.
It is
next
not in
time
the
it is
record
conclude.
also.
No, not that, but please be practical. Please agree to a date. You can have it on Monday or Tuesday.
Monday, my lord.
Tuesday, Lord.
Let it be till Monday.
Monday, my lord, because
For me, it will be difficult. Let it be on Tuesday. I'll also independently file it. At least Monday, I'll get the time. Let it be on Tuesday.
But Monday, you serve it on him, otherwise
Yes,
again
yes,
on
Monday
Monday,
will serve,
there'll be an adjournment.
Will serve.
my lord, Monday,
Will
because
serve.
time is running, my lord, because this issue is different, my lord. Otherwise, I am not going to pay, my lord.
Can't help it. You see, the advocate general is making a statement that will you circumvent the procedure? What will be the what will be your reply? What will your reply to the statement made by the Advocate General, whether the court will circumvent the procedure? If an affidavit is there, that's why I'm making a statement. If you don't press for that affidavit, then we can understand we don't.
Lordship,
We will,
I fully agree, Lordship.
We will prevent
Lordship.
an adjournment. Subject to Mr. Das's approach that he said that he is the complainant. That is one part. The second part is that if your affidavit is to be taken on board, then we have to give the respondents an opportunity. And you see, they will be filing it again, not before Monday. So even if they file on Monday, the requirement is that you take it up on Tuesday. You get an opportunity of referring to it. You want to send it to your senior counsel, you can do it in that meantime. But please try to understand. There is a procedure prescribed. If by the consent of the parties, we can overcome the procedures, that is okay. But if statement is made by an advocate not less than the stature of Advocate General, can I say no on an affidavit? That is the issue.
That cannot be, my lord, denied that opportunity. I understand, but considering the facts, my lord, how the division bench has directed, my lord, on these 2 points, my lord, I am
It's
just.
okay.
pressing,
You
my
see, you want to argue at 12 o'clock in the night. Please request the Honorable Chief Justice to constitute a bench at that point of
And
time.
he will have to provide us all supplements for that if we come at midnight.
No,
lord. Beyond my
you see that we can't expect because now you are at the warring. You are both at war. So peace between war we don't envisage. That is one part. But you see, I can't fix my roster beyond the quotas. What I'm doing is, although I'm extending my time at times to sit more than the prescribed time, please understand that I have 10 people along with me whose times are also precious. They will have to complete my dictation and give it to me for signing. In my courtroom, I can assure you that if the orders are not typed within 3 days, I have a complete list of those cases where my orders could not be uploaded. They are working very hard. If I sit till 5 o'clock, that means they are sitting here till 8:30. I go normally at not before 7:30 from the courtroom. So these are my parameters. I can't sit beyond the prescribed time unless the Honorable Chief Justice constitutes a bench at that moment. I have taken up benches on vacation. I have taken up bench on Sundays, not for movies, but for other serious matters. I have been allotted bench and I have hold courts on Sunday also. But that is by way of prescription by the Honorable Chief Justice. I can't fix my roster on a day when I want. I can't do it.
May I pray on the second half of the Monday, my lord?
I have some problem. I will file it. Tuesday is a better.
Let Tuesday, let it be at the top of the list.
Top of the
Lord.
list.
You make a mention, I am in my court, I'm not.
Monday, what I will serve the copy to them in advance. So they get in time. Not like at the
In
nick
my
of
court,
the
I
moment.
don't give that first on the list or top of the list. I don't make it, but make a request, we'll take it up.
Yes.
On Tuesday, Lord.
Tuesday.
Okay.
That's a
But-
hearing day, Lordship.
But no adjournment on that
No,
day.
No, I did not want. It is not my prayer, just it is a pleasantly surprised that they have filed a response. This is what he has conveyed to me. Well, I was sitting behind.
Okay.
We did not have the copy also.
At this time, Saranya, and counsel for the petitioner.
My lord, may I take a little time, my lord? Because it is because my senior, I have to inform whether my
Okay,
lord.
2 o'clock. That's the same. order.
I may not be here, Lordship.
Okay, I'll take note of your presence.
Yes, but on Tuesday, Lordship.
I'll take note of your presence.
Yes,
I'll record
yes,
it.
my other colleagues will be here.
Just I'll get an information, man, that I'll communicate it with you.
Only a time should be given till Monday, my lord. I'll file an affidavit.
So sometime maybe later, ma'am. At least 7 days is required, my lord. At least 7 days is required as informed by the branch manager.
Because what happens is that I don't know whether you know or not, but I am a common man. I go to bank for my transactions. I don't send my postmaster or my usher to go to bank do household chores for me. I go to the bank. And I find that whenever my account is operated, they will put on the computer along with my account, the mandate comes, they check my signature and clears my check immediately.
That's too good, but as informed.
No, I understand they have informed, but you see, I'm not that elite class who don't know how the bank operates. I go myself. You'll find me in this ATM withdrawing money. I do my own work. And I've never been disappointed by bank by saying that, sir, your mandate is in Guwahati branch of State Bank of India. At Bangalore, I will not be able to pay you your check. This never happened. So you'll ask the Ministry of your what you call chairman of the bank, State Bank of India, to inform us why they did not permit online mandate form to be available in your branch. We'll, instead of 7 days, we give you 15 days time, but the affidavit must come from your chairman, not less than director of a bank.
No, my lord, as the inform, they have sent a mail.
No,
to
that's
me, my
okay.
lord. That mail also forwarded to the branch. Whatever they say that, my lord,
I
as on
understand.
today, my lord, is online, my lord.
So online, just open it up. They just tell us, you can give a printout, they can send you
Earlier, my lord,
screenshot.
earlier from 2015,
No,
those
you
forms
see.
is not in online, my lord.
That's his accounts are not in online.
No, my lord, that is problem. So
Okay, if an online
now in online, my lord. As if somebody is open the accounts today, my lord, it is now online system.
correct. So we are asking your not less than a director to tell us why this facility is not there in Guwahati Bank. Do they treat this Guwahati Bank as a village branch?
No, my lord. But
Then,
my lord, they,
even in villages, we have that.
my lord, this the mail, my lord. They ask
No,
immediately.
that's okay. Mails and everything is okay. But I'm telling you, I'm a common man. I've used those facilities.
Sometime, my lord.
No, sometimes it's okay, but you see, you have stopped somebody's account.
Yes.
Who pays their tax?
Regarding of refreeze the accounts, we have no objection if honorable court direct, my lord. We are why, my lord, we hold that accounts only because of one of the partner, my lord.
That's okay. You see,
We have to look into the interest of the all partners, my lord.
it's
So that
okay.
is why.
I'm not saying that the statement, I have said that your statement is false. No, I've accepted everything. But if you say that your branch does not have an online operations,
No, online is there, my lord. Earlier, what happened, my lord, regarding that accounts is, this is a old accounts, my lord. Earlier, old accounts, my lord, that is not online, my lord. But as on today, my
so
lord.
my account here in the State Bank of India is in 1992 when I joined profession. My account in Bank of Baroda is 1988.
Sometime, my lord, next date, my lord, I will bless this.
In that event, my lord, may I pray for the, my lord, interim at least, my lord.
What it amounts to, you see, the difficulty is that it amounts to granting the entire relief.
No, limited
Once-
to, my lord, the liability,
No, I understand, but once you start operation of the account, then it amounts to.
will then
annual
come with the, my lord, mandate form on Monday or Tuesday, my lord.
Monday, if he communicates, he'll not be, tomorrow is bank holiday. You're fixing on 8th. Sorry,
My lord,
10th,
10,
10th.
my
9th, we have already fixed a matter. And 10th, it is the last day, but we are making an order very clear.
my lord.
If, these things are reported, then we'll ask your officer, not less than a director, to be filing an affidavit. It's absolutely not acceptable that the mandate form, the mandate is not available. How do you check whether the signature is correct or not, whether unauthorized signatures are coming or not? The mandate has to be there. If it's not there, you get it from Rokha, send a man. Auto is 150 rupees to Rokha. And don't ask me why I know it.
Regarding filing of affidavit, my lord, no problem, my lord. But my lord, here is a branch manager, is a party, my lord. As informed by the branch manager, that is the things, my lord.
That's okay. If he sends a man to a Lokra, how much would it cost the bank? It will be more than cost which we will be imposing. The auto fare will, to send a person to Lokra and get the mandate form. will
No,
be
no, they
cheaper than
already
to-
sent, my lord. After receipt of my, this is the mail, my lord, that's copy also forward to me also, my lord. Today they, my lord, mention everything, my lord, the branch manager, and requested to immediately provide this one, my lord. This is the, my lord, this letter is written as per
Okay,
verbal
okay,
discussion with
accept your statement. We'll fix it on 10th.
my lord, on 10th, my lord.
Okay. Also, it's represented, including the Sayan K. Chaudhary and senior counsel for the petitioner. First of all. Mr. I forgot your name.
K. Das, your
K. Das, standing counsel for the State Bank of India. Please for his granted time. To produce the mandate form, scanned copy of the mandate form of the
Two accounts.
of the account number.
That is, my lord, given at page 14.
Page
14, my. There are prayer 1 and 2.
Oh, okay. Account number. Page 14. 343 777 0919. Of the firm under the partnership firm in the name and style of Mrs. Pragati, PRGATI.
That is in Silpukri branch.
Silpukri branch.
My lord. One is in Silpukri branch, the other one at my lord, Hampton Road branch.
Okay, Silpukri branch. At GNB Road, Silpukri. And but there's only one account number.
There are two accounts, my lord. Prayer 1, my lord, one account number. Prayer 2, my lord, the other
Okay,
account.
this last number 919 is in which branch?
91.
It is Silpukri, my lord.
Silpukri branch.
Silpukri
That's
branch.
number 2.
And another account bearing number, same page 14, 330 396 27910 in the name of Mrs. Pragati at
MC Road branch.
State Bank of India, MC Road, Barwari branch. The learned counsel for the respondent numbers
2 and 3.
1, 2, and 3 shall send a downloaded copy of this order to the concerned branch of State Bank of India to get the account operation mandate form. So scan copy here. List 110 for 2024. Because you see, his grievance is that the accounts are closed. If the accounts is closed, then he's unable to run his business. There may be dispute between the parties.
My lord,
But still, you see, we need to know.
I
this.
understand, my lord, but
As
what
on today, the farm is dissolved. As on today, my lord, the farm is dissolved.
Farm is dissolved.
Yes, my lord.
That's all philosophy along.
My
with
lord,
farm
there
is
is a-
together. But the next state I'll find that. There is one very pertinent issue, my lord, which is the lordship. So I'll come up with an app. And.
But you should have filed it. You see, it's a highly contested matters.
I could have filed it today itself, my lord. The one difficulty with my respondent number 4 is busy with his son's marriage. That's the only issue. But by next state, my lord, absolutely.
Give it at least one day prior. Otherwise, Mr. Chaudhary has to get instructions. Right. File it by Monday so that you can get instructions.
And then.
There is a civil
regard
suit
to what-
pending, my lord, for rendition of account. There is a suit pending for rendition of account. But then, my lord, the private respondent here in D cannot get a relief. He could have filed a suit for, my lord,
No, that is different.
I'm not
We
really-
just try to apprise the court
Yes.
what has happened. So
he just
Why-
cannot get his relief by writing a letter to the bank.
my lord,
He
why-
cannot just get a relief of closing the account by writing a letter to the bank.
just see, let him.
I'm one of the partners, my lord. I write this.
It's okay.
Because
You-
two
you-
partners, my lord, they are withdrawing.
file your
most of
affidavit.
money, my lord.
You see,
What?
I have an
affidavit
affidavit.
is-
Otherwise,
Go to civil court.
unless I read, I can't retain.
My. Yes.
File your.
My instruction, this, my lord, my client is very specific to that particular issue, my lord. With regard to this statutory liability, my lord, I have absolutely no objection. But one thing is that let them file an affidavit, come up with a very specific assertion that this much of amount to be paid as a statutory liability.
Then, my lord, the
So
interim
that-
order may be passed, my
No,
lord.
you see, then,
to that
so then
extent,
it's
my lord,
okay, then nothing more remains.
Yes.
You see, the bank will not operate, allow any transaction except to government treasury.
Yes.
Government account. The tax paid will be to government account. Either it is to be the state government account or the central government
Well,
account.
the recital in the petition is vague, my lord. What is the quantum of
But-
liability, my lord? It's not.
Well, he is the
may be 1
partner who
rupee,
was-
it may be 1 rupee, it may be 10 lakh rupees. But if it goes to only the government account,
No objection.
then there is no objection.
Absolutely.
Then you allow this,
Then
we
yes, can
close
be,
this
my
matter.
lord, yes, can be disposed.
We can close the writ petition then.
And one important issue, my lord. So, when I got to know that because of this stoppage of bank account, the statutory liability are not being paid money, immediately I wrote a letter. There is another account, and they haven't mentioned it, another account in the Union Bank of India, Vishishta branch. They are about 10 years. So my information is concerned about 10 lakhs rupees is there. So I immediately wrote a letter to the bank manager.
You see, please put it on,
no,
otherwise it's very difficult for us to.
These are very
proceed.
important issue. I'll find.
Let him file it on Monday so that, my lord, I can respond.
File
to
it by
it.
Monday. It gets a time to respond,
Okay.
otherwise again it will be adjourned.
Mon-
We want to avoid adjournments.
My-
Because unless I have read it earlier, I won't remember, I won't be able to formulate.
Always.
Deeply obliged.
Item 13.
May it please the Lord. My lord, in the last occasion, there was a pertinent question raised that 111 of the Cooperative Societies Act, whether the CPC Order 47 or 114, that procedure of CPC will be applicable or not. But I have gone through some of the judgments of Supreme Court. Under the Advocates Act, my lord, there is a provision for review. That Advocates Act says, my lord, section 44 and 48 AA. 44 is review of orders by disciplinary committee. And 48 AA review the Bar Council of India or any of its committees other than its disciplinary committee may on its own motion or otherwise review any order within 60 days from the date of that order passed by it under this act. So, my lord, on this basis, my lord, on this subject, in 1971, there was a judgment held by the Supreme Court, where the Supreme Court has held, my lord, 71(3) SCC, page 5, paragraph 21.
Just a moment.
It is judgment number? Yeah. Para 21.
What is the citation?
71(3) SCC, page 5, para 21.
1991, 3 SCC.
71.
71.
3 SCC, page 5, para 21. May I read it, one?
Just a minute. Yes.
Para 21, my lord, as it says, the power of review are not circumscribed by the act. The analogy of the Civil Procedure Code must not be carried too far. Such powers may be exercised in a suitable case for or against an advocate, even after the matter has gone through the hands of disciplinary committee at some stage or even through this court. These matters are not governed by the analogy of atrophies convict or atrophies acquit in the Code of Criminal Procedure. Disciplinary proceedings against a lawyer involve not only the particular lawyer, but the entire profession. The reputation of the legal profession is the sum total of the reputation of the practitioners. The honor of the lawyer, the primary consideration, and they are intermixed. But I am here not on the other part, the first part, that the Civil Procedure Court must not be carried too far when there is a power of statutory review under the Advocates Act to the disciplinary committee, which will refer to the Bar Council of India. So CPC will not be applicable. This judgment was again discussed and referred and discussed in 2006. Malad, I am giving that judgment, that is. No, my 2018, sorry. 2018. Para 19 is para 2018, 14 SCC, 666. 18, 14 SCC, 666. My 2071 judgment, I am placing before your lordship. And as regards 2018 judgment, I am giving my para 19.
So today you are devil's representative.
My lord?
Today you are devil's representative.
My lord, my lord. Maybe I look like that also.
No, I'm not saying that. I'm not saying that, only a representative, because you are using 666.
My lord, 666. The omen, my lord. The omen. I remember the picture, the omen.
I don't know, strange things come to the mind.
My lord, my lord. My lord, that is 2018, 14 SCC 666, para 19. May I read it slowly? When we examine the review power of the BCI, but that is Bar Council of India, keeping in view the aforesaid factual metrics in mind, the necessary consequence would be to hold that in such a situation, revisiting the issue on merit, again on the pretext that the respondents was not granted proper opportunity to cross PW1, is clearly beyond the review jurisdiction. No doubt, in view of dicta of this court in O.N. Mohindro's case, that is 71 that I have just now given to your lordship, the review power of the disciplinary committee BCI is not to confined only confined within the narrow parameters laid down under section 114 and order 47 rule 1 CPC. At the same time, here what I want to place, my lord, the power also cannot be extended to the extent that the reviewing authority become appellate authority over its own order passed earlier. This is what I want to place, my lord. The liberty taken by the BCI outstrips even the wider amplitude and greater discretion that is granted to the Bar Council. It has reviewed its own finding of fact and overturned the same on the same material which was produced earlier and going on the same argument which was advanced earlier. This is what my argument is, my lord. If the order 47 and 114 is not also applicable, he cannot become the appellate authority. And my lord, in one of a judgment of this High Court, my lord, previously under the old act, my lord, section 80, subsection 2, review was there. Same language was there. Only there one judgment, my lord, single judge was there, which says the power of review is only with the register, not with the state government. But how it has to be applicable, how it has to be utilized is not there in that judgment. That is here, my lord, I'm giving. It has only said it has been vested with the or registered, not with the state government. That was there in the 80, so in the old act, same language was there. And now, my lord, another submission that will be from me, my lord.
Give this addition to him.
My lord, my lord, another that submission that I want to place before lordship, my lord. Your lordship will recollect the factual matrix that is there, my lord. In a review, what has been set aside? Petition to pay. My lord, in the review, the order dated 9th October 2021 was set aside. And thereafter, my lord, a new committee was elected. A new committee's board of directors meeting was approved. Everything was approved. Those were not before this court. And those things were never challenged by them before this court. And when they have filed an application, when the new committee was established, their application before the register was their application before the register is 25/4, if I am not wrong, my lord, I recollect the date. It was 25/4. My lord, page 37. Page 37, your lordship will find. Their application was filed on 25/4/2022. And when the new committee came into being, new committee, my lord, election was held in 17/4/22 and it was approved on 2nd May 2022. So the order which was set aside, it has become defunct. Nothing was left. New committee elected, no board of meeting, everything was there. And what was set aside? The earlier committee when a resolution was adopted. That is my submission, my lord. If the order 47 and 114 is also not applicable, my lord, still then the review power which has been given with the cooperative society register cannot act as an appellate authority while exercising his discretionary under 111(4). Four or three. Four, not four. My lord, I raised my case.
My lord, I have two judgments. I'll place that. Before that, my lord, the citation, my lord, which I have understood, I have not gone through it. 2018 14 SCC 666, my lord. This, my lord, ratio has to be understood in the backdrop of that case, my lord, because the disciplinary committee, my lord, was in fact the Honorable Supreme Court was considering the power of the disciplinary committee, having regard to, my lord, the provision of, as I have, my lord, understood, 114 of the Bar Council of India rules, my lord. And
44. Advocate side.
44. So the provision, my lord, which has been, my lord, prescribed or envisaged therein, has to be understood the power which has been conferred by that provision itself. So therefore, the power of review under the Bar Council of India rules, my lord, has been circumscribed. And I'll come to the, my lord, section 1112.
I'll just tell you, in this case, what had happened was, in this case, the concerned lawyer, he was held guilty of misconduct.
Right.
And 31/7/2005 order was passed by the state Bar Council.
Right.
Thereafter, appeal was preferred. In the appeal, the Bar Council of India reduced the punishment awarded to the respondent by debarring him for a period of 18 months and fine of rupees 25,000. After that, a review was filed under 48AA. And the review application was allowed by setting aside the previous order and directing fresh consideration of the matter. And this order was challenged. And in this context, these facts you will find in paragraph 1 and 2. And in paragraph 24,
I'm giving, my lord, I'm giving one.
Well, my lord.
You see, you have seen para 2, please come to the first line, para 2, statutory appeal preferred by the respondent before BCI, which was disposed of in the appeal by order dated 10/9/2021. Correct?
Mal.
Now come to page para 24, first line.
Yes.
The outcome of the aforesaid discussion would be to resuscitate order dated 10/9/2011 passed by the district committee of the BCI.
Right.
And then in this last three lines,
right,
at the end, in these circumstances, we permit the appellant to seek recall of order dated 1/9/2016 passed in so and seek restoration of the said appeal for his for decision on made. To sum up, the setting aside order dated 17/11/2015 passed by decision earlier order stand revived. Before the first order stood revived. In the appeal, when the review was filed, that order was set aside. That is the crux of the matter.
Yes, yes, correct. What I am trying to say, if the power of review is not circumscribed by the statute or the rule thereof, then, my lord, the review has to be understood that it is a, my lord, power of substantive review. Now, what, my lord, I have understood, subject to what your lordship says, my lord, going through some of the Supreme Court judgments, my lord, I have found that the Honorable Supreme Court has classified review, my lord, into two categories. Your lordship is aware. One is, my lord, procedural review, And the another is, my lord, substantive review, review on merits. Now, there is one earlier judgment, 1971 3 SCC, page 844. That, my lord, I'll hand over to your lordships, my lord. Here, it would be also,
1971.
my lord, 3 SCC, page 844. Now, here what had happened, the commissioner of Rajkot, my lord, he passed an order which was amounting to review. Now, the contention was that since, my lord, the act or the rules thereunder did not contain any provision for review, so therefore the order passed, my lord, itself is a nullity. And this particular, my lord, contention was accepted by the Supreme Court. If I take your lordships, my lord, to para 4.
Yes.
I'm starting this, my lord, with this judgment because subsequently this judgment has been, my lord, in fact, distinguished or it has been further clarified by the Supreme Court. So this would be necessary, my lord. I'm reading it out 4. The first question that we have to consider is whether Mr. Manduki had competence, my lord, he was the commissioner of Rajkot, to quash the order made by the Saurashtra government on October 2256. It must be remembered that Mr. So-and-so was functioning as the delegate of the state government. The order passed by Mr. Manduki in law amounted to review of the order made by Saurashtra government. It is well settled that the power to review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. No provision in the act was brought to notice from which it could be gathered that the government had power to review its own order. If the government had no power to review its own order, it is obvious that its delegate could not review its order. The question whether the government order is correct or invalid in law does not arise for consideration in these proceedings, so long as that order is not set aside or declared void by the competent authority, and the same cannot be ignored. So therefore, what the Honorable Supreme Court says, that when the source of power is not available, the, my lord, review cannot be done. Now, subsequent to, my lord, this judgment, my lord, this is a Greenlace Bank case. My lord, the power exercised by the tribunal was challenged, my lord, before the Supreme Court. The tribunal had set aside an order which was amounting, set aside an ex parte order, which was amounting to exercise the power of review. Now, the Greenlace Bank argued before the Supreme Court, saying that since under the Industrial Dispute Act or the rules thereof, it contained no power of review. So therefore, the power exercised by the tribunal is wrong. And my lord, this Patel Narsi's case, my lord, 71 was referred. Then in this context, what the Honorable Supreme Court says, my lord, is important. I take your lordships to para 13. There, my lord, the Honorable Supreme Court had propounded, my lord, the principle of procedural, my lord, review and, my lord, substantive review. Your lordship has got para 13. I'm reading it out, my lord. We are unable to appreciate the contention that merely because ex parte order award was passed on the statement of the manager of the appellant, the order setting aside the ex parte award, in fact, amounts to review. The decision in Patel Narsi Thakresi's case is distinguishable. It is an authority for the proposition that the power of review is not an inherent power. It must be conferred either specifically or by necessary implication. Subsection 1 and 3 of Section 11 of the Act themselves make a distinction between procedure and power of the tribunal under the Act. While the procedure is left to be devised by the tribunal to suit carrying out its functions under the Act, the power of civil court conferred upon it are clearly defined. The question whether a party must be heard before it is proceeded against one of the procedure and not of power in the sense in which the words are used in Section 11. The answer to the question is therefore to be found in subsection 1 of Section 11 and not in subsection 3 of Section 11. Furthermore, different considerations arise on review. The expression review is used in two distinct senses. My lord, this is important. Namely, a procedural review which is either inherent or implied in a court or tribunal to set aside a palpably erroneous order passed under a misapprehension by it. Number 2, a review on merits. When the errors sought to be corrected is one of law and apparent on the face of the record. It is in the latter sense that the court in Patel Narsi Thakresi's case held that no review lies on merit unless a statute specifically provides for it. Obviously, when a review is sought due to a procedural defect, the inadvertent error committed by the tribunal must be corrected ex debito justitiae to prevent the abuse of the process, and such power inheres in every court or tribunal. Now, what I have understood, my lord, irrespective of a provision in respect of review, every court or tribunal or a quasi-judicial authority will have a power of review so far as the procedural defect is concerned. This is, my lord, a procedural review. But a procedure, my lord, a review on substantive ground or on merit cannot be, my lord, made unless there is a provision to that effect on the statute, my lord. So doing, my lord, ex-debit quasi-judicial authority will have the power of review. So that is, my lord, in respect of the procedural review. But, my lord, when a statute contains the power of review, my lord, not only the, my lord, procedural review, it will have the power of substantive review also, my lord. So therefore, having regard to, my lord, 1112 and the language of subsection 2, if your lordship sees, my lord, subsection 2 does not circumscribe the power of the register in respect of the review, my lord. It is wide enough. So reading subsection 2, my lord, what I understand, apart from having, my lord, the power of procedural review, the registrar has also, my lord, the power of substantive review, my lord. Because procedural review, my lord, is inherent in every court, tribunal, my lord, and quasi-judicial authority, my lord, for the purpose of ex debito justitiae, my lord. And there is another judgment, my lord, subsequent to this one. Same, my lord, principles has been reiterated by the Honorable Supreme Court. This is in Kapra Mazdoor Ekta Union, my lord, 2005, 13 SCC. Lordship may go through para 17, 18, 19, my lord. I'm not reading it out, my lord. The same principles have been laid down. So therefore, my lord, my submission is, this is a well settled, my lord, proposition of law. That unless the provision is circumscribed by the statute itself, my lord, the power of the authority cannot be restricted, my lord, only in respect of the procedural review. Because the procedural review is inherent in every authority, my lord. So having regard to the language, my lord, of subsection 2, 111, the registrar may review any order passed by him at any time within 60 days from the communication of the order. So in my respectful submission, my lord, this power is not circumscribed, my lord, by any condition. Therefore, the registrar is empowered to review his own order even on merits, my lord, and thereby come to a different findings, my lord. In that view of the matter, the order under review, my lord, under challenge, my lord, does not suffer from any infirmity. Though, my lord, the findings is different with that of the earlier one. So to this limited point, my lord, this is my understanding, my lord, and I have placed before your lordship.
The lordship promised me, though, again it will be repetition, my lord. 111 says two words, appeal or review. They could, what my learned friend is saying, procedural and substantive. In a substantive review, my lord, it cannot go with the understanding. He has given a finding that because the ARC has not given a document, that is why, my lord, the last signatory has done that. He has totally changed his own view. He cannot be an appellate authority. And more regarding procedural and substantive, in a 226, my lord, in a 226 application, there is no statutory provision written down of a review. That is a procedural review. But in a CPC, this is a substantive review. There is a provision laid down. 114 and 47 is procedure. Substantive is 114 is there. There is a procedure. In a Cooperative Societies Act, power of review is laid down. My lord, in a BC Advocates Act, power of review is laid down. It cannot be inherent. It's a fact. Right? It cannot be inherent. Only in 226, my lord. 226, there is a inherent power that we are using, my lord, because of 141. My lord, I'm subject to all my corrections, my lord. It's not that my lord, I only think going through, my lord, I try to, my lord, assist the court. That is why I'm saying, my lord, in a 226 is a procedure. It's not laid down. That is my submission. And my lord, the earlier committee becomes defunct, and that order was set aside. And new committee, everything is still holding the field.
The second order. Oh, yes.
Only on technical aspect, your lordship, legal point, they have argued, your lordship, and on that day, my senior counsel, Mr. Binidas, has advanced his argument. Now, the only point is that, your lordship, he is pressing that the first allegation is made after the subsequent election, your lordship. What happened, your lordship? This AGM, which could not be held within time, it was held on 3/10. And as per the statutory requirement, the AGM ought to have been held by 30th September of every year. Once it crosses the date, your lordship, by operation of law, even no order is required. By operation of law, the body shall stand dissolved. So on 3/10/21, the AGM was held. There is overwriting and tempering. That fact has been held in both the review also and in the earlier round of order also. The registrar has held that there is a tempering. And if your lordship goes to the record, apparent on the eye, the lordship can see that there are severe tempering. 3/10 has been made 39 just to legalize the earlier body. Now, what happened? An election was due, your lordship. On 3/10, the things happened. On 19/10, he filed a representation, which is at page number 107. As a chief executive officer of the department of the society, he ought to bring the same to the knowledge of the higher authority. He brought the same that the meeting could not be held within the time. That was only the thing, your lordship. Now, on 1/4/2022, the election and AGM notice was issued by the chairman, your lordship, which is not permissible under the act. It should have been issued by the secretary, your lordship. But they have taken away all the records from the secretary. And what happened? The chairman himself issued the notice, lordship. If takes up my affidavit in opposition at page number 110. No.
For holding the election.
For holding the chairman knew that his body has in the meantime dissolved. So what happened? He convened the AGM, your lordship. On 1/4/2022, he issued the notice at page number 110. If your lordship has seen it, it is the chairman who himself has issued the notice, which ought to have been done by the secretary, but he was not given that power. He was kept out of all these things, your lordship.
He was removed from the post.
No, let me complete.
Yes, on 1/4/2022, immediately thereafter, he made a representation at page number 112 on 12/4/2022, because the election was fixed on 17/4. So he made a representation on 12/4 that the body has already been dissolved. This body does not have the power to convene another AGM or the election itself. Page number 112, your lordship. This is my affidavit in opposition and the serial page, your lordship.
Yes.
So here, lordship will see that ARCS, after getting this application, his representation on 12/4, ARCS has directed one serial inspector of Cooperative Society 1, M.H. Tapadar. You are hereby instructed to inquire about the claims and to submit detailed update report within 7 days. So what happened? They are in hand in glove with this officers, your lordship. Absolutely, the inquiry was not held. Then when he came to know that things are not working, again he made a representation on 28/4/2022. Even after the earlier complaint, your lordship, they convened the illegal election on 17/4 with the virtually dissolved body, your lordship. On 28/4, before giving approval, he made a appeal to the registrar, your lordship, at page number 113.
Election was 17/4.
17/4, they have conducted the election, your lordship.
Which year?
2022. Before that, he made a representation. There was a direction to conduct inquiry. But since they are in hand in glove with this ARCS, the election was convened, your lordship. And virtually the earlier body has been re-elected, uncontested, your lordship. If lordship goes through the AGM minutes, your lordship, the earlier dissolved body that has virtually been re-elected without any election, your lordship. So the earlier body is now also the new body, your lordship.
So on 28/4/2022, he made a representation to the register. And pursuant to this representation, the register convened different dates, and ultimately the register initially was of the view that yes, there is tampering of the document. To that, the register had no doubt, your lordship. The initial order was passed on 4/8/2022 at page 116. The register in that order also, initial order also, the register hold the view that there is a tampering of documents. But what the register's view was that since the records ought to have remained with the secretary, so it would have been the secretary who would have tempered the documents. That was the view. So far as tampering is concerned in both the orders, register has held that yes, there is tampering of documents, and even if a lordship goes to the record, even on an open eye also, it can be seen there is tampering. Now, what benefit the secretary will get after tampering the documents? So I am not onto that. So ultimately, your lordship, this the register initially held that it should have been the secretary who have tempered the documents. So I have filed a review, your lordship. During the review, they were also duly represented. The new body said that we are already a new body. That matter was also before the register. The register was aware of the fact that the earlier body has dissolved and the new body has come into force. And that body, the chairman, he was also the earlier chairman. And the whole body is virtually re-elected on the election of 17/4/2022. And they have taken that plea also that we are now the new body. But the register have gone through the record and hold that if your lordship see the tempered documents, who had convened this illegality. At page number, the tempered document lordship will get at page number 97, it starts. I have given. I'm only on the facts, your lordship. Page 97. It is in Bengali, your lordship. Initially 39/23/10/2021 has been changed into 39/2021, and it was Sunday, Ravivar. That has been changed, your lordship. In the writ petition that has been changed, but in this petition it was the earlier original one. Ravivar is clearly written. But if you see, if your lordship sees this annexed to the writ petition, this Ravivar has also been changed and it is made Brihaspativar. So the last page is important, your lordship will see on what basis the register has hold the view that the chairman has done it at page number 106. The last page of this minutes, the tempered minutes. So the meeting ended after putting of signature of the chairman and the secretary on 39/2021. Thereafter, the file was with him, and thereafter the chairman made 2 additional points. And he has taken one view that the secretary is not entitled to function from now onwards, and something like some decision he has taken. And thereafter, it is on this basis, the register has come to a finding that since from the record it is seen that the last person who has signed the document is the chairman. He alone has signed this document. And thereafter, it is he who should have submitted the document, because if he can change the date, it is the body which will survive. The secretary has nothing to gain after tampering with the documents, your lordship. And on this basis, the honorable register has said that no, it is the chairman who has done. Therefore, the body is defunct by operation of law. Even no order is required. If the time limit is crossed, your lordship, by operation of law, body stands dissolved. And since the subsequent election was conducted by a dissolved body also, the subsequent election would also go. And therefore, this order was passed, your lordship, holding that a one-man committee should be formed and immediately an election should be held of the board of directors. That is my submission on facts only, your lordship.
My lord, the reply to my friend's query is this: where is this challenge to the new committee? Where is this challenge? Factual, this 226.
That you have already said. That you have already said.
My lord, he has not challenged it, has left open. Only by placing those facts in a my requisition, he cannot get a relief, my lord.
The submissions of Mr. P.K. Roy, counsel for the petitioner, Mr. S.K. Talogal, standing counsel for the Cooperation Department, and Mr. M.S. Lesker, counsel for private respondent, are concluded. The order is out.
I reflect the name of my senior counsel in the final.
Sir.
BD Das.
BC Das, senior counsel, assisted by
BD Das.
Oh, BD Das. BD Das, senior counsel, assisted by Mr. M.S. Lesker. Judgment is reserved.
Obliged, Lordship.
Obliged, Lord.
Obliged, Lordship.
Mm-hmm. 33.
My lord, here a peculiar situation has arisen. We were, my lord, the complainant in respect of a particular person.
Public prosecutor will be here.
My lord?
Public prosecutor must be here.
Yes, my lord, he must be there. My lord, we have informed he will come, my lord.
Let him be here.
Yes.
Mr. KK Das was here.
My lord, somebody was here.
After some time.
My lord.
Item 27.
Yes.
As per office note, Lordship, service report of 1, 3 and 4, Lordship, yet not updated. Not returned.
I think you'll take first steps.
Lordship.
Last was taken long back.
Long back, okay.
In August 23, you took last steps.
Your Honor, as per verbal instruction, I am appearing for respondent number 3.
Respondent 3,
Two and-
2 and 3.
Yes, Your Lordship.
Okay. You file your affidavit?
Yes, Your Lordship.
Well, that's it. In view of office note dated 11/3/2024. The petition shall take, Mr. D. Dole. Mr. D. Dole, counsel for the petition, and Ms.
DS Neog, Your Lordship.
DS Neog, counsel for respondent number 3 and 4 are present, 2 and 3 are present. Yes, in view of office note dated 11/3/2024, the petition shall take fresh steps for service of notice on respondent number 1 and 4 by registered post with AD. Yes, sir. The learned counsel for the petition is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. On the prayer made by learned counsel for respondent number 2 and 3. How much time to file affidavit?
That's it.
How much time to file affidavit?
2 weeks, Your Lordship.
2 weeks' time is granted for affidavit in opposition in the matter. You have quick first steps. The notice is made returnable on after 5 weeks.
Then he, I,
205/2024. The
upgraded item 33.
I apologize, Lordship, I was on.
It's okay.
mistake, Lordship.
It's okay.
But if this case has been actually gone through by learned APP Lordship, Locker, PS Locker. So his, due to his personal difficulties, Lordship, he was unable to come, Lordship. Maybe fixed on Tuesday, Lordship.
Usually those are very close to
Yes,
vacation, a very
vacation.
difficult position. But you'll have to show us, Mr. Tawagdar,
Madam.
why a writ petition for quashing?
Well, I'm relying on Bhajan Lal's case. 226 is maintainable. And 226 is maintainable, my lord, for quashing of the FIR and my lord charge sheet. That is maintainable. And in fact, my lord, there are letters, my lord, from the SP, my lord, border police to the deputy commissioner, which is also under challenge, referring the my lord matter to the my lord, in fact, asking the IO, my lord, to approach my lord the Assistant High Commissioner of Bangladesh. In fact, my lord, in long and short, what my case is, my lord, there is a procedure prescribed under the CRPC. There is an express provision of law under 166 capital A. My lord, when certain evidence is required to be collected from the outside of the country, my lord, an application has to be filed before the magistrate. And the magistrate, my lord, will issue a letter of request. Now, this discretion, my lord, rests with the magistrate. And subsequent to that letter of request, my lord, the IO may proceed in the matter. And central government has, my lord, it has devised a procedure how, my lord, the letter of request will reach, my lord, the outside authority. Now, here what has been done, bifurcating all these provisions, my lord, they have directly approached, my lord, the Assistant High Commission at situated at, my lord, Silpokhori. Now, Assistant High Commission, what it did, my lord, it said that the documents provided by us could not be traceable. That is, my lord, their findings. But what effort has been made, my lord, that is absolutely not indicated. Now, on the basis of that, the police have arrived at, my lord, findings, or rather a conclusion, my lord, that the documents produced by us is, my lord, manufactured documents. My lord, essentially what we did, we submitted certain documents before the, my lord, border police, saying that a particular person is maintaining dual citizenship. He is also a citizen of Bangladesh, and which is, my lord, prohibited under the Constitution as well as under, my lord, Indian Citizenship Act. So, in fact, my lord, a stringent procedure or a scrupulous investigation was required to be done. Rather, now what has been done, that we have, my lord, manufactured document, my lord, criminal prosecution is initiated against us, man. So we are against this FIR and the charge sheet, my lord, saying that the material which is collected is divorced, my lord, of a, my lord, mandatory provision of law. You cannot do that. A certain procedure is prescribed, and what 166 capital A says, that the central government will, my lord, devise the procedure, how it will go. That has been done. I have annexed the circular of the central government, Ministry of Home Affairs. And the material which is collected will be considered as an evidence, my lord. Now that has been, my lord, collected absolutely in violation of the procedure prescribed by law. And that material cannot be used against us, my lord, as evidence. And Bhajan, that when there is no material to prosecute, my lord, then 226 or 52 is maintainable for the FIR or the charge sheet. This is my lord, long as my case, my lord. If your lordship comes to Bhajan Lal, this is, my lord, 1992 supplementary 1 SCC, my lord. The relevant para is para 102. These principles has been laid down, and pursuant to Bhajan Lal, my lord, the Supreme Court has been followed in numerous cases, my lord. This is the foundation and basis your lordship is aware. I am, my lord.
Page number was?
Page number 378, my lord. para 102.
This is 2002 one SCC.
My lord, no, this is 1992
1992 supplementary one
supplementary
SCC.
1 SCC, page, my lord, 335. I take your lordship to page 378. If I read 102, my lord, it becomes clear. In the backdrop of the interpretation of
Okay,
very,
just a moment.
my lord, sorry.
Yes.
If your lordship comes to 102, in the backdrop of the interpretation of various relevant provisions of the code under chapter 15 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of ordinary power under Article 226 or the inherent power under 482 of the code, that is CRPC, my lord, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad cases, kind of cases wherein such power should be exercised. Now, I rely on, my lord, principle number 3, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. If your lordship comes to the charge sheet, your lordship will find that here, my lord, is a case where documents relates to, my lord, authority, my lord, issuing, my lord, by an authority out of the country, that is Bangladesh. And the police, my lord, have visited local places at Hajj, where the, my lord, accused resides or the person resides, and thereby, by examining some of the, my lord, persons, my lord, they have come to a conclusion that these documents, my lord, are fabricated documents. And the evidence and the material, my lord, which has formed the basis of such a findings, my lord, is the report by the Assistant High Commissioner of Bangladesh, which has been obtained in violation of 166 capital A. If your lordship, my lord, for the time being comes to 166.
No, I was just examining only one point about the 226.
My lord, no, this Honorable Supreme Court has clearly said, my lord, 226, my lord, is maintainable. for filing, for quashing an FIR or a my lord complaint and consequent charge sheet, man. There are other paragraphs also where my lord 226, my lord, the honorable court says 226 maintainable. Apart from 482. And 102 is very categorical, my lord, expressly provided.
Yes, when will he do it? When will he do it?
Lordship on Tuesday, Lordship.
Tuesday is very close to.
Otherwise, Lordship, he stated me to 20 to 25 April.
What is happening to the prosecution?
My lord, for that, my lord, I am making a prayer that now we have been dragged to a criminal prosecution. And my lord,
what is the stage?
My lord, in fact, someone has been issued. The last date, my lord, I think it's in the first week of May. Some interim order may be passed, my lord, saying the proceedings, my lord, of the court below. In PRC case number 727/23, pending before the learned judicial magistrate first class ho jaye.
Okay, we're listing out 22nd.
22nd April.
Clear that if
22nd April.
22nd April, we are making in the order clear that
Fine.
if for some reason the matter will not be heard, you appear for interim review.
My lordship will make it clear.
For Mr. S.K. Talukdar, counsel for the petitioner. Mr. S.K. Talukdar, counsel for the petitioner is present. Next, Mr. K.K. Das, learned APP submits that this matter is assigned to Mr.
PS Locker.
Mr. P.S. Locker, learned APP, who is
Difficult.
who could not attend the court today for personal reasons. Next, at this stage, the learned counsel for the petitioner has submitted that the prosecution of the petitioner has commenced, and the proceeding before the trial court is fixed sometime in May 2024. Next, accordingly, it is provided in the event the matter cannot be taken up on the next date. Prayer for interim, the interim prayer shall be considered. Next, list on 22/4.
23rd, my lord. 23rd, my lord.
23rd.
My lord,
23/4/2024.
it should come as a motion item because notice in respect of other respondents have not been issued. Only in respect of the my lord, official respondents it has been issued, my lord.
No, that means the notice is not required there.
Correct.
That is why is there.
So it should come for admission, my lord, not as an order item, my lord.
Okay, the admission item as in the admission column.
Well, obliged, deeply obliged. 23rd, my lord. Obliged.
28.
28.
So this contempt case has been filed for alleged violation of order dated 12/9/2022. The direction was issued to the authorities to consider the case of the petitioner for allotment of land and shall pass appropriate orders within a period of 6 months. So, my lord, their hearing has been conducted on 2-3 occasions, but till today they have not taken any decision.
Lordship, to resolve this issue, Lordship, the government of Assam Revenue Department, VC and petitioner has conducted 2-3 hearings. And now government is, today I'm talking with the respondents, they are saying that 2-3 weeks they are required to pass a speaking order. Lordship. And a report was also called for from the DC, the same was also received by the authority. Lordship. After 3 weeks, Lordship, we can produce a
Compliance, Your Lordship.
You give it 8.
Lordship.
That may be fixed.
After 7th of May, Lordship. Any date, 7th of May. Lordship.
Okay, then 10th of May.
10th, Lordship. Lordship.
Represented.
Madam.
On the period made by Mr. S. Datta, Council for Respondent number 1. Matter is adjourned today to enable him to file affidavit in this matter. Next, matter, the respondents are put to notice that indeed their personal appearance in the court has not been exempted. So therefore, the respondents shall ensure that their affidavit in opposition is filed at least 2 days prior to the next date of listing. That's what list on 10/5/2024.
Obliged.
File your affidavit, otherwise it
I-
will be difficult for you.
Twenty-nine. Item 29.
No representation from the petitioner. It's fair to see that service on the respondent is not completed. That's why according to the petitioner shall take first steps for service of notice on first step within a week for service of notice on the respondent by registered postal ID. The petitioner is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Petitioners. 30.
Please apply.
Did you give after 5 weeks?
Item 30.
What is the number of this? Yes.
Lordship, the item has already been complied with. The matter has already been complied with.
Upon instructions, Miss
I'm Miss P. Bora on behalf of Mr. K. Borua.
Ms. P. Bora on behalf of
Mr. K. Borua.
Mr. K. Bora, counsel for the petitioner. On behalf of Mr. K. Bora, counsel for the petitioner. Has submitted upon instructions that the order of this court dated 9/6/2023. Sorry. This is dated 9/6/2023, passed by the Honorable Judicial Magistrate First Class, Golaghat, in GR number 19 of 2023, has been complied with. Next, accordingly, this contempt stands closed on satisfaction.
Highly obliged.
31.
May I please, Your Lordship? Lordship, pleadings in this case is Lordship is pleadings is exchange Lordship respondent number 3 has filed the affidavit of opposition. Accordingly, we have also filed our reply. And Lordship, in regards service of notice upon respondent number private respondent number 5, the office note dated 14 March 2024, Your Lordship will find service is also complete upon respondent number 5, Your Lordship, private respondent. Lordship may fix this matter for admission hearing after Bihu vacation, Your Lordship. Pleadings has also been exchanged. Lordship.
Okay, notice is served on him.
Yes, it is
Respondent
served,
5.
Lordship. We have taken steps and that steps is already served. Service is complete, Your Lordship. Office note, Your Lordship will find
Dated
14-3.
14/3/2024, Lordship. That flag, there is a flag, Lordship, flag P and Q before that, Lordship.
Counsel for the petitioner. Respondent number 1 and respondent numbers 2 to 4 are present. As per office not dated, as per proceedings of the Lahore Court dated 14/3/2024, notices served on respondent number 5. None appears on call for the petitioner. As pleadings have been exchanged, this is matter for hearing.
Yeah, admission hearing, Lordship.
For admission, in the admission column. After the new vacation.
Lordship, may I pray for a date, your Lordship?
I'm not giving it right now.
Lordship.
You make a mention if it is not
Meta
possible,
pardon,
because-
Lordship, this demolition of the house, Lordship.
No, because you see, after vacations, we have very hard test of a slot. Make a mention if it is not listed.
Okay, any date, your Lordship, convenience.
Mention. Make a mention if it is required, otherwise we can give you a May.
Yes, only May it will go. May,
May.
in the month of May. Deep level.
May I present? In terms of order dated, Wazima Court order dated 25/1, my lord.
Yes.
Notice upon the private respondent number 5 is served, my.
My lord, I have instruction to appear on behalf of respondent number 5, my lord. I'll file my Okala number by Monday, my lord.
Okay.
And my lord, what happened, my lord? Immediately after vacation, since short time is there, my lord. Because, my lord, in this case, what happened? Private respondent number 6 and 7's election as a board of director is challenged, my lord. On the ground that, in terms of the provision of the act, they are required to attend in 2 meetings for last 5 years. Here is a case where the respondent number 6 and 7 are not attended in 2 meetings, my lord, in last 5 years. In their affidavit, they have filed. In that also, they have stated that one member has appeared in 1 meeting and the other member has not has appeared in 2017 1 meeting and 21 meeting. So he is also not qualified, my lord. So this is why, my lord, AGM, my lord, election for the board chairman of the board of directors is about to held, my lord. If anything happen, my lord, that will, my lord, has some ramification. That is why, my lord, immediately after vacation, your lordship has a convenient date.
When is your election slated?
Lordship?
When is your election slated?
Election was held on 23, my lord.
Election was held on 27/8/2023. 27/8/2023.
23.
Yes,
Yes,
ma'am.
sir.
So next elections will be
after 5 years, sir.
After 5 years.
after 5 years.
And my lord, after the election of the board of director, there is procedure to elect 1 chairman and 1 vice chair. That is about to held, my lord. That is not held.
For 1 year, it has not been held.
Not held.
That has not been held.
And if by the votes of this disqualified members, my lord, any member chairman is elected, my lord.
Okay. All sides all sides except respondent of 5 are represented. Oh, sorry, you are for 5.
My lord.
All sides, including counsel for respondent of 5 are present. Thanks, Mr.
Yes, Hazarika.
Yes, Hazarika, counsel for respondent of 5. Submits that he has appeared on verbal instructions and will be filing his wakalatnama within a week. Next, the
27.
Mr. J.M. Chaudhary, counsel for the petitioner, submit that there is some urgency in the matter. Next, this is in the admission column on 1/5/2024.
Deeply.
Affidavits by the Respondents may be filed this 2 days prior to the.
Lordship, I have sent it for heading. In the meantime, I'll file.
I said 2 days before that, we'll file it.
Obliged, Lordship.
Item 36.
Yes.
So we have taken steps upon the respondent lordship. Service is awaited, but my allotment is okay. I don't know.
You're appearing for the respondent.
Lordship, today we have entered appearance in the matter for the respondent number 1, Bantana Das, by filing Wakalatnama. Lordship, we may be allowed 4 weeks time for filing affidavit.
What about 2 and 3?
Service is awaited, lordship. No ID card has been returned by lordship.
Okay. Counsel, with the
Lordship, in this
petitioner and respondent 1 are present. Next, on the prayer made by counsel for respondent 1. 3 weeks time is granted to file affidavit in opposition in the matter. Next paragraph. Service on respondent was 2 and 3 is awaited. Okay. Based on 3/5/2024. The affidavit by respondent number 1 shall be filed at least 2 days prior to the exit or listing.
lordship, in this case, we have filed an IA, lordship, for stay of the arbitration petition, lordship. We have filed an IA for stay of the arbitration petition, lordship. That may be tied along with this and may be listed on Monday or Tuesday, lordship. Lordship, if
That
the
is
order
not
dated.
here. That is not here.
Yeah, we have filed it yesterday, lordship.
Okay, along with interrogatory application, this was along with the interrogatory application filed by the petitioner in the matter.
Thirty-seven.
May I please?
Lordship, I filed my Wakalatnama on behalf of the sole respondent in this contempt case, Your Lordship. This is regarding the payment of the ex gratia amount.
Yes.
So Lordship, after filing my Wakalatnama, I've appeared for the first time in this case. Your Lordship would kindly grant me some time to file my affidavit.
Okay.
Also, Your Lordship, in the main writ petition, there was the deputy commissioners were a party in the case, in the main original writ petition. Actually, in this contempt case, only the Revenue Department Principal Secretary has been made a party, Your Lordship. Your Lordship, in ex gratia matters, the proposal is sent by the Deputy Commissioners to the Revenue Department, Your Lordship. If the DC is a party in the contempt case, it becomes easier, Your Lordship.
So this is SI account counsel for the petitioner. Next paragraph is unpopular and counsel enters appearance for the respondent and place for him is granted 4 weeks time to file affidavit in opposition in the matter. Next paragraph, the counsel for the respondent number 1 has submitted that for release of ex gratia, the proposal is to be received from the deputy commissioner concerned. So, counsel for the petitioner shall take note of the said submission. It's called the affidavit in opposition shall be filed at least 2 days prior to the exit of listing. List after 4 weeks.
In this matter, your lordship, two
The
districts.
tendency of the contempt petition shall not be a bar for the respondent to comply with the order of the court.
Deeply.
Lordship, in this matter, two districts are involved. In this matter, two districts are involved.
It's okay, I'm saying
Yes,
that
sir.
it will not be a bar for you to.
Yes.
38.
Deeply.
Yes, Mr. Saikia.
Yes. The order was passed by the High Court directing them to release the acquired amount of money, compensation.
Lordship, I may be allowed to file affidavit in opposition. Lordship. I may be in correspondence, but
Respondent number 3 is not served.
3 is not served, not appear.
Who is number 3?
Deputy Commissioner.
The page 13, my lord, may kindly be seen for a while of this case. Page 13, 1-3.
1.
1-3, annexure 2. Sir, with reference to the subject cited above, I have the honor to enclose herewith copy of the court order passed by the Honorable High Court in respect of WPC number 1162 of 22. Directing to pay the remaining balance amount of rupees 7,51,214 only to the petitioner Sri Bhadendra Kumar Gwari within a period of 3 months for compensation of the land acquired by the National Highway. Hence, you are requested to release the required compensation amount for payment to Sri Bhadendra Kumar Gwari within the stipulated time frame. Accordingly, this is my lord, the ADC on behalf of the DC has issued the letter to the respondent number 2, my lord, project director. Now project director, whether he has released the amount, I do not know, my lord.
She wants some time to.
Yes, I'll file affidavit, Lordship. We have already released the amount. That's why, Lordship,
Right.
I want to file affidavit.
Mr. Hasi Saikia and counsel for the petitioner. Mrs. Arbora, that counsel enters appearance for respondent numbers 1 and 2.
1 and 2,
And raised for and it's granted 4 weeks time to file affidavit in opposition in the matter.
Lordship.
Next paragraph. The petitioner shall take fresh steps for service of notice on respondent number 3 by registered post with AD. Next paragraph. The learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. The pendency of this contempt petition shall not be a bar for the respondents to
Release them.
comply with the order dated 12/5/2023, passed in WPC 1162 of 2022.
Lordship.
If not, all be complied with.
Lordship. Because we have already deposited the amount.
So if not complied with, that's why I
Yes,
added,
yes, the DC actually, she has not
that's
released.
why I've added that.
My friend is appearing on behalf of person number 1 and 2.
1 and 2.
Project director.
3, you have to take first steps.
My lord.
Yes.
Notice is made returnable on.
We are grateful, my lord, to my friend that the
2/05/2024. Notice, just notice returnable on response.
obliging.
Obliged.
Take steps for service of notice. There you have notice made returnable on so. Last line only, this one so.
The item 45, 46.
Orders.
Lordship.
May I
Yes.
plead your lordship? Lordship, I will file an affidavit. I am appearing for the writ petitioner in item number 45.
Item number
45.
I'm also appearing for item number 46. We also
no,
file
just,
affidavit,
just,
my lord.
just a moment, one by one. In this item 45. This is IAU, right? This interlocutory application has been filed for vacating, modification or alteration of order dated 7/6/2023, passed in WPC 2817 of 2023.
Interim order is there, lordship.
Your order is already expired. 226 operates. If you are asking for time today, will not help you. So constitutional provision, what can be done? Interim order would stand vacated automatically by now. You take instructions and come back within 10 minutes time. Ask someone
Yes, sir.
and come back. Your interim order is no longer there. 226 operates. You ask someone and come back.
Yes, sir.
No, I understand. I've been waiting for 10 minutes. This, you have this, there's no other matter. I'm waiting for 10 minutes for your take instructions to come back. Then
আপনার ইন্টেন্ট ব্র্যাকেট হলে আমার তো অটোমেটিক ব্র্যাকেট হয়ে যাবে ব্র্যাকেট আমি জানি ওটা কোনো ফাইল পজিশন বন্ধ না পাবো ফাইল পজিশন কিন্তু এখানে এটা একটা পার্টি বিষয়ে এখানে আজকাল নাই ইংরেজি ফোন আছে না জানো মুখোশ পার্টিসিপেট করেছেন 46 of your position in the requirement only 45
আমার উঠে গেল আপনার পৌঁছে গেলাম
এটা ঘটানো এটা লক লগালে
What is the reality, Mr. Sarojat, in ground level, what is happening?
I have to obtain instruction, my lord, because now latest instruction I don't have. And perhaps written instruction I have not received also. Lordship may take up after vacation, my lord. I will apprise your lordship.
For Mr.
N.A. Mazarbi.
N.
A. Mazarbi.
N.E. Mazarbiya.
Yes, lordship.
Then counsel for the applicant. Mr. S.K. Talukdar, standing counsel for the Corporation Department, and Miss M. Begum on behalf of Mr. S. Banik, counsel for the petition, for the lead petitioner. Public, within bracket, yes. Opposite part number 1. This interrogatory application was filed on 22/12/2023. For for vacating of the interim order dated 7/6/2023 passed by this court in WBC 2817 of 2023. Next comment. The counsel for the opposite party number 1 has opposed the prayer for vacating on the ground that the matter was district for the first time today. Next part. The provisions of Article 227, the bracket 3 of the Constitution of India is quoted below. Next paragraph. From the above, it appears that the constitutional mandate is that if the application is not disposed of within a period of 2 weeks from the date on which it is received, comma, the interim order would stand vacated from the expiry of the said 2 weeks period. Next, therefore, comma, by operation of law, the operation of law, comma, relating to provisions of Article 226 within bracket 3 of the Constitution of India, comma, the interim order passed on 7/6/2023 stands vacated. Next one, nonetheless, comma, in view of the nature of challenge made in the connected petition, comma, the election of the managing committee of Gandhi Gram Samavaya Samiti held on 10/5/2023 shall be subject to outcome of the connected petition. Interrogatory application stands allowed, comma, subject to conditions as mentioned hearing before. I tried to find out, there is no judgment. I found that this 15/3 has been read down.
My lord,
There is no judgment reading down to 26/3.
I'll try to find out, man. Perhaps application again can be filed. Perhaps there is some.
No.
Yes. I'll try to find out.
I tried to find out, but I did not get one.
Yes, correct, correct.
There's some There's some adjudication on Asian resurfacing. Are you aware of that? No.
No.
Asian resurfacing has been revisited. The interim order vacates within 6 months. Like that. I'm not getting it. This is 3.
My lord. In item number 46, my lord. We are ready with the affidavit, my lord, but the council, I have called them, my lord, they are no longer in that. That's why. The council, Mr. Hussain, R.S. Chaudhary, in fact, the matters are.
Which
They have
council?
not filed Wakalatama, I don't know. Well, they have not filed Wakalatama in 46 also, my lord. In item 46, the council.
You're not appearing 46?
Lordship, on that regard, I need to take
Yes,
instructions.
I don't know
because
whether to-
Wakalatama is not being executed. But same petitioner is there also, Lordship. Applicant is same.
Applicant is, those
Applicant
applicants
of
need to
inter-
file Wakalatama, my lord. So how can I know? Item 46.
What is the petitioner is Sambhu.
I'm for a petitioner, my lord.
Uh,
Then I has been filed by Saurabh Das, my lord.
I is not there with us. I আসেনি কি?
They're in the cause list. IA number 3035/23.
3035
/23, my lord.
isn't 46.
46, my lord.
Yes. This is IE
For stay vacation, my lord. Though the affidavit ready, my lord, the opposite the applicant who has filed IA, I called them, they are no longer in the case, my lord. I don't know where to reserve copy, my lord. That's why.
No, once you see, once parties on record, they can't say that they are not there.
They are not appearing also last occasion.
You are for the applicant.
Yeah, I'm for the repudiation, my lord.
Okay. None appears on call for the applicant. However, Mr. A. Bhattacharya and counsel for the opposite party number 1 is present. One and Mr. S.K. Talukdar, standing counsel for the cooperation department, are present. For enjoy justice matters and judge on today. Next para. The learned counsel for the opposite party number 1, public rate petitioner, submits that the counsel on record for the applicant is refusing to accept copy of the affidavit filed by which is ready for being filed. Next paragraph. In view of the statement so made, comma, the court permits the opposite party number 1, i.e. the writ petitioner, to file affidavit in this matter, and on and production of the order of the download copy of this order, comma, the registry shall accept the filing
Yes, my lord.
without service on the learned counsel for the applicant. Next paragraph. However, comma, the learned counsel for the opposite party number 1 shall keep a copy ready with it for being served on the counsel for the applicant as and when they appear. List after 2 weeks, interim or past in the connected references stands extended till the next date of this time.
Lordship, may I fix a date, Lordship, kindly.
After these vacations, there's a lot of problem. A lot of administrative problems comes up. That is the difficulty. You make a mention.
So interim order shall be continued, my lord.
Interim, in your case, I have continued.
I have like, my lord.
Obliged, Lordship.
You are unable to manage lists immediately after vacation. Before vacation, nobody does the matters. 50% case gets adjourned. And then 50% all express their urgency after vacation every time.
Every vacation, lordships. Every vacation, all are done entering the.
Because in bench, otherwise in bench 5, to rise at 4:15 is otherwise difficult.
Yes. Otherwise difficult.
Otherwise difficult.
And to exhaust the list.
I requested the bar many times. Whenever this such occasion arises, I tell the members of the bar will see you. You should have a discussion and tell us what to do. Because the solution must come from you. Instead of the bench imposing conditions, I think it must be deliberated in the house and then told us what should be the correct way to proceed. Because everybody will have their own ideas. So if I satisfy you, Mr. Bhattacharya would be unsatisfied. If I satisfy him, maybe Mr. Talekar would be dissatisfied. It's very difficult, and it leads to conflict between the bar and the bench.
Yeah.
In order to avoid that, we've been requesting many times. The bar should deliberate and find out a solution. You see, a few days back, there was a viral message circulating about 1,600 cases. If there the bar wants that the matters be listed. So at one point of time, in an average, you check the cause list of Rajasthan High Court. Have you checked it?
No.
Just check it. Just check cause list Rajasthan High Court.
Rajasthan High.
Just check it. On an average, you will find 600-700 cases listed in every bench.
600-700.
So on that day, the one of the honorable judge was absent, and therefore there was a double roster to the another bench.
So 14,000, more than 1,000.
Yes, on an average, you will find 500-600 cases listed there. Any given bench.
Weekly cause list. ऐसा ना? वो weekly कौन है भाई जो? Weekly cause list.
A few honorable judges who can cross 100, maximum will go from 50 to 75. So because of that unique situation, that the bar requests that the date be given. So when dates are given, every day it costs.
And thereafter, my lord, prayer is made to adjourn. Those are there, my lord.
No, adjournment is this okay. The question is even, you see, that amount of list also is very impracticable. That's why I'm saying that perhaps the bar when they deliberate, so that there will be no objection to the procedure accepted. Nowadays, what is happening is that we are taking up hearing at admission stage. The part 2 or the hearing which we can't teach.
Yes, correct. Those matters are lying.
161.
161.
Today.
In one court, 161 matter. 161.
It is court number 3. Yes.
Wow.
That will be division bench.
That is division bench. Yes, yes.
No,
Correct.
court
Division
number
bench.
Court 3 will be division bench.
Division bench.
The division bench 161 matters.
Select court, I think.
It's okay, but we know it. We know it. So that's the problem. Because when it comes to messages, you get only one side of the story. That is the second side of the story.
Correct.
Because if you give a fixed date, then this happens.
Yes, correct.
But the issue then have to list it.
Yes.
So immediately at the time of vacations, they always come and request us not to give a fixed date. Immediately in and around vacations. And then they are unable to manage. There are other difficulties also. One honorable judge, maybe according to his choice, he may handle 100 matters, he gets 100 matters listed. But then on that particular day, I come in.
Yes.
I may not be in the capacity to handle 100
Yes.
matters. I may handle, say, 30 matters. So 70 lawyers go dissatisfied, 70 into 3, government, respondent and petitioner, 370 to 3, 210 lawyers goes dissatisfied.
Correct.
So just think and multiply, you'll find that position is very bad. So times in these cases, the election of cooperative society is not that urgent. You have to bear with us.
Correct.